Page mention, please. Page number 1, item 1 to 7.
Item 2, ending taking up next week.
Item 1 was kindly taken on next week.
Item 1.
Yes, madam.
What is your good name, sir?
SUBHASIS fine. Yes, fine.
The requested is S1 and council. The applicant let the matter be listed on 26th of September 2023.
Item number.
Yes.
Item 2. Ending taken on next
No,
week.
Mr. Dev,
Yes.
is the same order? The same day, no? 26th.
Next week only,
Not possible next week.
Suppose please to grant time for translation of the documents containing India text. Because for English I have not translated.
For our convenience, since you have not done it, I will take the assistance of the company and judge. There is no issue. On that ground, I am not. I am not ready. Why you are the one giving the responsibility that I am not? It will come in the next month on 27th of September. At the request made by Mr. R.N. Pustil and Council, appearing for the petitioner, let the matter be listed on 27th of September 2023. Yes, sir.
Item 5. Item 5.
Just whether this item number 2, who mentioned the matter?
Mr.
Dev. He has left it.
Where is that order?
Tell him. Just send the message to come at any point of time.
Telephone number must be there, so something.
Item 5.
5, my lord. On behalf of
In this matter, there is any order item number 2? Yes. So it's not required. That order has submersed. Okay.
item 5, my lord.
Item 5.
On behalf of Momata Misra, my lord, she is ill. So I pray short adjournment in this matter.
Last occasion also you took time.
My lord.
Last occasion also you took time. You are Mr. Mahapatra?
No, my lord. I am on behalf of her. I am
Right. Last occasion Mr. Mahapatra appeared and took time for Miss Mishra. I don't know, that order was passed on 28th of July. Today we are almost after 29 days. All right. Your name, sir?
A.K. Jena, Oxford Jena.
The request of Mr. A.K. Jena, Learning Council, who takes an instruction of Ms. M. National and Council for the petitioner, let the matter be listed on 22nd of September 2023. Mr. Mohanty usually appears. Are you appearing in this matter?
Mr. Dipkant Mohanty.
All that he is not here presently. Is it defects?
1, 2, 3, 4, 5, 6.
In the meanwhile, the defects as identified by the registration will be removed. Next.
Page 2, item 8 to 16. Page 3, item 17 to 21. Page 7, item 22 and 23. Page 8, item 24 to 28.
Any pattern? Item 24.
And I played it tomorrow because I was absent yesterday. I will retap it. Item number 24. I only play tomorrow. I'll prepare a soft note and I'll see. Just tomorrow. Okay. I'll do it tomorrow. Just
Item 23 million. Just previous page.
23.
23 million. Northern Council, Senior Council, Mr. Roth is appearing. Today is mother's death anniversary. So I pray for a next week, Miller.
Give a date in the next week. 29th of August. 29th of August.
Mail only.
What is the good name, sir?
Hemant Kumar actually.
The request of citizenship.
Page number 9. Sir.
Item 26, Mr. Pilot may come and call it 1 week later. Already taken the consent of appellant. We haven't responded. We will see some accommodation
What
later.
is the good name, ma'am?
I am not reading it.
The request of Ms. A. Pradhan and Council appearing for the. You are appearing for the Legislative Assembly?
Yes, Your Lordship.
Appearing for the respondent. The matter will be listed on 29.
May I have the pardon?
Have you informed Mr. Das?
Yes, Your Lordship.
Sure, there will be no objection.
And we have already taken his consent. May I have the pardon? Let's manage item 12 on behalf of Mr. Pilot may kindly.
No, item 12. It's over. Next, you wait for the item, turn of the item 12.
My apologies.
Page number 9, item 29 to 32. Page 10, item 33 and 34. Page number 18, item 35. Page 19, item 36 to 39.
38 one. 38 is a part matter and it also specifically fixed to 2 p.m. And also 34 that batch of matter also to fix 2 p.m. And in item 38 already my conference already completed its argument. Only 5 minutes required. For my
Please take a look.
prior to the 34 I only because the
Already,
34 will take some time.
all right.
My obligation.
Page 20, item 40 to 44.
Lordship, item 40, Your Lordship. Today morning, my learned friend has requested me. Lordship, may I kindly 1 week after, Your Lordship. It is a state revision and question of law has already been admitted, Your Lordship.
Where is your learned friend?
Mr. Deora or my rather requested me that 1 week after. Please.
The request made for matter use behavioral and council came to the respondent. The matter be listed on sometime 14th September 2023. 14th of September. Mr. S. Mishra and its standing council, city and VST appears for the petition. Yes.
Page 21, item 45 to 50. Page 22, item 51.
Mr. Mishra,
Your Lordship.
when this matter has not come up?
Come on 25th, Your Lordship.
This
Friday.
This is
Friday.
the small question that you have raised.
Lordship.
Friday.
Friday, Your Lordship.
Friday, there will be hardly any time anyway. Already Friday.
First article mentioned.
Page 21, item 45 to 50. Page 22, item 51 to 59. Page 23, item 60 to 65.
Where the item 61, my lord.
Yes.
If the matter is not taken up today, maybe the given listed tomorrow. Because the appellant is a retired
Mr.
person.
Naik, just wait, huh? We'll try to accommodate you. Be there at 12:30. All right. We'll just initially check up if the matter can be disposed of that time. We'll take up the matter at 12:30.
Yes,
We'll be there at 12.
Oh, right, man.
We'll call the matter at 12:30.
My lord, item 63, my lord.
Yes.
Item 63, my lord, is a pension matter, my lord. I pray, my lord, if possible, may kindly taken up today, my lord. Retired since 2015.
You just be there in 3:30.
Yes,
All
obliged.
right. Make it on 3:30.
Page 24, item 66 to 68.
Item number 67. In this matter, another writ application which has been disposed of by this honorable court, the point raised in that case, the very same point has been raised in the present case. That has been decided. That number is WPC 16940 by 2018. 16940 by 2018. Disposed of on 14/2/2020. Both the matters have been taken up any other date.
There is a 31306/2020.
Yes, that is the connected writ application, present writ application, arising out of writ application.
Okay, that is the separate.
Separate case. So in that case, all points have been decided and again has been registered here.
Tomorrow. let the matter be listed on tomorrow, give the date only, along with WPC number services.
16940 by 2018. Disposed of on 14/2/2020.
As it has been stated by Mr. S.K. Pari. You are Mr. Pari.
No, I am Swine, Sanjeev Swine.
Mr. S. Swine. And Council, you are for the appeal for the state or private respondent?
The private operator.
Appeal for the private respondent. Has stated that the judgment passed in WPC number appeals to High Court the controversy raised by the present teams.
It will come tomorrow.
Tomorrow. Let us examine, because it is the single bench judgment, what you are referring to.
Similar, between same parties, same point, everything.
All right. Let us see hear the other parts. Mr. S.K. Pari, just you be informed by Mr. Swine and Council in the course of the day. Next.
Page number 26, item 69 and 70. Page 27, item 71 to 77. Page 28, item 78 to 80. Okay.
Pardon to mention by the writ appeal number 87 of 2023, several opinion mentions were listed on this, not this. The matter is like this, my lord. The senior judge awarded 10 graduate scale up to the in favor of the respondent employee. That was challenged, stay granted, and by the similar order has been passed by this and in several cases. So let the matter come tomorrow, at least to dispose of matter. Tomorrow, day after
tomorrow, let the matter come day after tomorrow.
Not day after.
Let us see.
Then another matter.
You also just give the number. This where according to you, the similar matter has been decided. Where is those numbers? You give a slip to this.
I'll file certificate copy at the time of hearing.
All right. But don't take the opposite side by side.
No, I already, there's an hour of the state matter.
All right.
Another thing I got. Mother, I'm a retirement benefit of a son.
Day after tomorrow, we'll take up the matter.
Day after tomorrow. But another matter, my lord, regarding the retirement employee of a Soini school of a teacher, and that matter is hearing concluded. Honorable Court directed to give what is the financial benefit involved, and that is ready, and that is also disposed of within 2 to 3 minutes. That matter taken on yesterday.
Who had heard it?
This Honorable Chief Justice,
Then it has to be heard again.
His memory has not transferred to us.
No, there is a judicial order there to file the affidavit regarding their.
That you have to make a phrase.
Another matter that next week at least. Next week.
Week on 29. You will come on 29. Come prepared.
Yes, ma'am.
29.
Yes, ma'am.
Madam, I need pardon to mention, my writ appeal number 1343/23. This is a fresh writ appeal, my lord. I am for the respondent number 2 and 3. I am on candidate. The connected matter was already disposed of your lordship as infructuous, my lord. What has happened? 2 writ applications were filed. One by the respondent number 2 and 3, and one by the appellant in the writ appeal mentioned. Both were disposed of by common in my favor. Let me see. Well, I'm not able to know because after that.
Part of it is already disposed.
I don't to mention, my lord. The habeas corpus petition, my lord. Minor gal of the petitioner, my lord.
May I please your lordship? PIL file number 24,295/23. PIL file number list.
Coming the next week.
My lord, I am for the respondent. Appellant file a single judgment before the Honorable Court in W number. Respondent is working more than 23 years in sweeper post. Not a single judge pass order and direct the appellant to comply the order 2 months. They are filing a writ appeal without complying the order. So that my case is urgent.
They have right to file the appeal.
My lord?
They have right to file.
Yes, my lord. Only file writ appeal. They are not mentioning anything to
receive notice from the court.
No, sir. No, my lord.
All right. Take up the matter tomorrow.
Yes, my lord. All right. I beg your pardon, my lord.
You just remember and remind me that the steps are not taken.
Well, this is a fresh PIL matter, my lord.
Next week.
Yes,
well, it is content matter. Content petition filed on 4th February 2022.
Perhaps I will find several names, but it could not be listed till today.
What charge sheet you mentioned now? Because it's almost more than a 1.5 year.
I have mentioned several times, but it could not be listed. I am challenging the order of the 14th September 2021.
Just inquired from the registry why the matter is not being mentioned. Listed. You just check up, some difficulty may be there. Have you filed the certified copy of the order?
Yes, madam.
And what about the section 20 of the Contempt of Courts Act?
If the executives not complied with the order of the
Section, you are referring to section 12, I have section 20.
I am no idea.
Limitation cognizance has to be taken within 1 year.
1 year.
So already 1 year is over.
I have filed within 1 year. I have challenged the order of the 14th September 2021. I have filed the petition on.
I'm talking about the cognizance. I am not even filing. Doesn't save it. You have a responsibility also. Already we'll check up the matter.
Pardon to mention, my lord, it is review out of a surfacey writ, which was the order was passed by Honorable Justice Jaswant Singh and Justice M.S. Sahu.
As to the registered judicial, mention the matter. If he doesn't, for any reason, raise the matter, then come to the bench.
Highly appreciated.
One fresh PIL matter, Lordship.
Supplemental list, item number 3.
Lordship, may I be permitted to make a mention one fresh PIL matter?
It is not on list, Mr. Pani.
Not on the list. It's a
Already
fresh matter.
taken in the next week. You said the mention memo to your associates. Okay.
They have already started filling the tree today, and I have filed this case on 9th August 2023.
Already, they filed the memo. We'll try to take up the matter on day after tomorrow. Because there is day after tomorrow.
May I please?
Yes.
Item 3. My lord, at Annexure 1 at page 13, this is the appointment order, common appointment order, where the petitioner's name find place at serial number 21, page 14, my lord. He was appointed on contractual basis as professor in General Surgery Department. My lord, may kindly have a glance at page 15, my lord, the terms and conditions of the appointment. May I be permitted to place, my lord, serial number 5.
Okay.
Page 15, my lord.
Mr. Amit Mishra.
Abhijit.
Amit Mishra, serial number 5.
No, my lord. He has serial number 21, my lord, petitioner.
Okay.
Subhasis Mahapatra. The terms and conditions at the subsequent page, my lord, 15, page 15, my lord.
Yes.
Serial number 5, my lord. The appointing authority can terminate the tenure of by serving an episode 30 days. The concerned faculty may also resign by giving 30 days notice. The next is 7, clause 7, my lord.
Yes.
The faculty shall be relieved as and when the post filled up by regular selection or promotion. These are the terms and conditions mentioned in the appointment order, my lord. And this institution is an autonomous body, my lord. My lord, thereafter, my lord, at Annexure 2, this relates to assistant professors who were appointed on contractual and deputation basis, my lord. They, in anticipation of completion of 4 years, they were issued with this notice, my lord, that their 4 years will be completed on a subsequent day, that is at the last second column, those dates, and they are issued this notice before 1 month, saying that you will be removed from this post. And along with that, the director also issued an advertisement to fill up this post.
Yes.
My 6 of these assistant professors approached this honorable single judge, and my lord, where this interim order was passed in all cases, and they are still continuing. My lord directed not to fill up those posts, and the selection process has been stalled, my lord. Here, this is a case where they are assistant professors, my lord. This is one of the order which I have given. There are 6 cases. I have mentioned the numbers also.
No, we are concerned with the writ appeal now.
My lord, here this petitioner is a professor.
Yes.
And the post is lying vacant. Here, the other case which I am referring to, there an advertisement was issued to fill up the post, and that has been stalled. Pursuant to orders passed by this honorable court. But here, this petitioner suddenly was issued with Annexure 3, my lord, the renewal order, notice of 1 month, and this 4 years, who's there, may I place my answer 3, pay 17 million. Dr. Srivastava Kumar Mahapatra, Professor General Surgery, contractual, is hereby relieved from his institution after completion of his tenure of 4 years. This is not the contention of the appointment order. In addition to that, this was fixed by the government for government medical colleges. That is, and subsequent annexure 4. May I place my letter? But the government had said that a person who is appointed in a medical college on contractual or deputation basis, if he completes 4 years, then he has to leave the place. And the final last order issued by government is at annexure 9.
No, just this question from this court. What is your right on that post?
This is the appointment order. The basis of my what they say.
Just tell us what is your right on that post.
No, I have this limited right that I have been appointed by this certain terms and conditions without issuing any notice of 1 month according to their appointment order. They have done it, and the reason they have given by the time of the answer answer 8 is 23 million. This is the last order issued by government.
Yes.
With reference to subject cited above, it is to intimate you that renewal of professor, assistant professor working on contractual deputation basis on completion of 4 years of tenure issued by directed letter such and such is hereby kept in abeyance. The government which had issued the order has kept that order in kept in abeyance, and this has been communicated to government medical colleges.
Yes.
And basically on this they are relieving. And so most importantly, this issue involved in this batch of rate petitions has been stayed by the same singles. Now that the order has been issued and may placement annexure 9, the next page 24, the HOD has recommended his case that the post is lying vacant, and therefore his tenure should be extended in anticipation of the fact that that will be completed in 4 years at annexure 9. The representation has been recommended by the HOD of the department, and his report is at 11 is periodic appraisal. Here, what happened in this case, the honorable single judge, what the order has been passed is that you approach the petitioner is permitted to make a fresh representation before the department of fee. In that regard, within 2 weeks, which will be considered. But the representation has already been, without taking into consideration the representation at annexure 9, he has been removed. The appointment order, the terms and conditions of the appointment order has not been complied with. And similar matter, the same honorable single judge has passed interim orders where those 6 assistant professors are still continuing even after 4 years. It is a limited time. Only in pre-minor, this petition will be protected till disposal of those 6 petitions, because the issue is
how this matters is similar. How this matters is similar.
But the appointment order is same.
Occupying the post of professor.
The common appointment order.
Sir, occupying the post of the assistant professor.
There is a common appointment order. And sir, one, they are also there inside in that appointment order.
It is a combined order, is all right.
And terms and conditions are same, my lord. And the post is like vacant, most importantly.
How without notice you can terminate?
My lord, my only submission, your lordships has pointed out that they are assistant professors and this is a professor. Your lordship may only see page 1, the memo of parties. Page 1 of the writ of appeal, the memo of parties. The petitioner is Dr. Srivastava Kumar Mahapatra, aged about 69 years.
They can work till 70. That's the NMC guideline. That is not the ground on which they have been
assistant. That is not the ground.
Well, my instructions are the superannuation age is 65.
No. He is continuing after retirement.
Regular doctors, not the contractual. Contractual is 70 years.
Well, he has.
So take instructions.
I'll take instructions on this part.
Well, he has worked.
Only what he is contemplating till the post is regularly vacated. If he is otherwise fit to continue, well, you allow him to continue the post. Okay. Let the matter be listed tomorrow or day after.
Day after tomorrow.
All right.
Well, most importantly, this person has already.
National Learned Council appeal to the appellate with the request of Mr. A. Behra, Learned Additional Standing Council. Let the matter be listed on day after tomorrow. The day. Meanwhile, Mr. Behra shall take the instruction as to why the termination has been caused without the notice, and also whether the appellant can be accommodated till the regular faculty in the post of professor is appointed. On these two aspects, you come. A copy of this order be supplied to Mr. Behera. Both ways. All right, come. Let us see day after tomorrow.
Deep blue, please. Item number 6. Item number 6.
Well, it appears when the matter is taken up. Mr. Mohanty, have you filed this?
No, my lord, I have not. I'll come.
Then the matter will listed on last chance. Now it continue.
3 weeks time, maybe not.
14th, I am fixing the matter. 14th of September.
21st September.
14th of September. The matter is listed on 14th of September. The request of Mr. D.K. Mohanty, National Government is a claim to the opposite parties. Can very verify their counter affidavit. Thus, this court will not provide further accommodation. Now, it is for the petitioner of the matter is taken up next.
Item number 7.
Item 7, I clear your lordship.
Yes.
We read petition in nature of PIL lordship.
Yes.
Here the petitioners, who are the displaced portion of Upper Kola irrigation project, they have been rehabilitated in colonies, but there are not any facilities, your lordship. Nothing help, water.
Mr. Mohanty, first of all, there are two aspects. They want the take action on the basis of your own inquiry report.
Yes, your lordship. That is annexed to your lordship. Annexed to.
And secondly, to declare their habitation as the revenue of village. That is a long-run process. We are not going into or consider whether that can be done or not. Because either it will be annexed to a revenue of village or itself will be declared as a revenue of village. This is an administrative process it goes through. But the amenities, this is bare minimum amenities should be extended to them. Because this is a rehabilitation village.
Yes, madam. Yes.
That way that we are disposing the petition.
Madam.
But Mr. N. Lenka, the Grand Council appealed to the petitioner. By means, here Mr. Lenka, I think.
Mohanto, your lordship.
Also, H.K. Mohanto. I'm seeing after a long time. Mr. H.K. Mohanto, Grand Council appealed to the petitioner. This is public interest litigation. Anything to see this? By means of this petition, which is in nature of public interest litigation, the petitioners have asked this court to direct the opposite parties to take a decision on the representation by the petition as Section 1 to this petition. After taking into consideration of the inquiry report submitted by the opposite party number 5 and technique of this petition. So we have further asked that why the colony number 7 of Upper Kola irrigation project shall not be declared as revenue of village with all other facilities. So, there are clearly two parts of the village. First one is comprising to extend the facilities to the said rehabilitation colony number 7. And the other is for declaration of the revenue of the village, so that the petitioners can get the facilities from the administration. So with the first prayer is concerned, we direct the opposite parties to take the decision, having due consideration of the inquiry report submitted by the opposite party number 5 and shifted to the reputation within a period of 2 months from today. Mr. Mohammed, 2 months from today.
From the date of communication of the order.
From the date, 2 months from the date of the communication of this order.
By the petitioners.
Function order by the petitioner. So for the second prayer is concerned, we direct the opposite party to consider the aspects whether this quality can be declared as a separate revenue village, or that can be made the part of the other revenue village, nearby revenue village, so that the government facilities can be extended to that rehabilitation colony with stuff. You have also heard Mr. E. Mohammed, additional government advocate appearing to government in terms of the group applications. This represents this first time. Yes.
Item number 8. This is a public interest litigation. While the villagers of the Khanibara in the district of Jaispur, the Gochar land has already been recorded in favor of the father of the opposite part number 4 and 5, and they have sold the property to the opposite part number 6 to 8, my lord. Also, kindly see Annex 1, that is, the land is to the extent of 3 acres 72 decimals, my lord. The first Annex 1, page 19, this is a Rakshit Khata. There are page 21, you also kindly see, till on 12/7/2022, the land is recorded at the Gochar, which they have obtained under the RTA Act, Right to Information Act. Page 21, you also kindly see, to the PIO consolidation officer, they have given the report. Plot number 3, that is in Odisha, my lord. Plot number 3504, that is Kishamij Gochar, 1.24 decimals. 3875, that is also Gochar, 0.62 decimals, 4020, 1.86 decimals. The total extent of area of that Khata number is 48.89 decimals, my lord. Thereafter, what happened, my lord? They have taken a plea, the opposite part number 4 and 5 have taken a plea. In the case, under Odisha State Abolition Act, the land has been recorded in the name of their father. When the villagers applied for the OEA record, that is the order was filed in the OEA case, the Tahsildar stated OEA case record bearing number 375 of 6, also Annex 4, page 30, that is 375, 62, 63, not available. Send the CA for RR for further action. The application for copy of OEA case record bearing number 375 of 62, 63 is rejected. Under the Act, the OEA record is not available. Therefore, my application, the villagers' application for record, I rejected, my lord. And next page, you will also kindly see that is the sub-register has given a report to the letter to the Tahsildar, and in that letter, the RR, the supervisor, has stated on the basis of the OEA case, the land has been recorded Annex 5, page 31, my lord. The entire fraud has been committed, the Gochar land has been recorded, and they have already executed 2 sales in the year 2021 in favor of public part number 6 to 8. That's why the villagers before this honorable court, they are giving representation to the collector, as well as the Tahsildar, my lord, by the Annex 7, Annex 6, my lord, but no action has been taken, my lord. In the year 2022, the consolidation officer has given the report, under the RTA, the land is still at the Gochar, my lord. And the Gochar land cannot be settled in favor of anybody, my lord. And they have executed 2 sales, my lord.
Yes, Mr. Mohanty.
I will take instruction. I will take.
I think
last time it is listed.
Just to record, there should be a hearing on the matter.
Yes, the notice has to be issued.
Just to
Yes. Or your lordship may direct the collector to examine this, because if he has filed a representation before the collector,
That is
That
what
is
I was
at page 33.
Well, the OA case record may be produced before this honorable for
We are not passing any order. We are not
That is not in PIF.
too much land comes in. First of all, these are dispute relating to the land.
Land and cell deed is challenged. A registered cell deed can only be challenged.
because that they have said on the basis of a OA case that has been recorded. They didn't provide the government challenge.
I'm asking the collector because
I have filed the collector.
all right. Because this part of the disputed fact, you should not expect this will be decided by the High Court in a public interest litigation.
This is a mature land. Otherwise, if you provide
And that is why you are taking some time for this. You are Mr. Mahanti.
no, no.
Mr. December Mahanti and counsel appearing for the petition. By means of this public interest litigation, the petition has advised this court. Interfere with the settlement of the mutual land in favor of the father of the
Per number 4 and 5, my lord.
per number 4 and 5. For the same land has been recorded here. Data number 3447, plot number 3504, measuring an area of 078. Plot number 4020, measuring an area of 1.82 hectares. And the total area of land has been settled in favor of the father of the other parties number 4 and 5 is 3.26 hectares. This is in the village.
The village Kormikapada. Kormikapada under the Akhtarpur block in the district of Jajpur. Dehu decide, my lord.
It is under district Jajpur.
advocate clerk welfare code ଅଛି
Daswatpur Tahsil.
ଯାଜପୁର ଲିଖିଛ
ଟଙ୍କା
ଏବେ ଯାଜପୁର change ହେଇଗଲା।
50 ଟଙ୍କା advocate ମାନଙ୍କର
is wrong.
Not to
ନା ନା ତହସିଲ କୋର୍ଟ ଯାଜପୁର ଅଛି। ତହସିଲ କିଛି ଲେଖିନି। ତହସିଲ କୋର୍ଟ ଦେଖିଛି। ପୋଷ୍ଟ ପିଏସ୍ ଲେଖିଛି।
not to reserve the situation land. In the interest of the community.
ସେଇଟା ଦାସପୁର ହବ। ହଁ ଲୋଲେ ପେମେଣ୍ଟ କଥା।
It appears some allegations of fraud have been made against the office of the Tahsildar
We declare
in respect of the second. The petition has explained that
ଭୁଲ ହବନି ମୋର
they have advised
ମୋ ଆଖି ବହୁତ ପ୍ରାଣ
one representation since come to the place 33. This particular place 33. It is addressed to the collector.
But the Tahsildar is not included as a party.
No, the
Tahsildar has given him RTI information.
But Tahsildar, no, the PIO of the consolidation.
Anyway, but Tahsildar,
Because if the records are not available,
yes,
the information will be given. That is not
the entire responsibility is on the Tahsildar. Because the records.
I beg to pardon, my lord. I have wrongly typed the Tahsildar Jajpur. That should be Daswatpur, my lord.
That should be corrected because otherwise they will download the read petition. So this is a very material mistake.
It has been also stated by Mr. Mohanty that the petitioners tried to mine out the information taking recourse to the section 6 of the Right to Information Act 2005. but such information was not disclosed on the ground that the records of
case number 375, 62, 63.
case number 375/1962/1963 is not traceable. Stop. The petition is filed a representation on 8/9/2022 at 6 cities. Requesting the collector just to inquire into the matter and reserve the virtual land for the community boards. So, it is written by Mr. Mohanty and council that no decision will be taken on the same representation. At least the petitioners have not been communicated about the outcome of the same representation as yet. In such circumstances, we direct the collector judge to conduct an inquiry by providing the due opportunity to the opposite parties number 4 and 5 and pass the appropriate order
on the representation dated 8th September 20.
In accordance with law. Such consideration shall be made within a period of 4 months from the date when the petitioner shall furnish a copy of this order to the collector.
By the petitioner.
Mr. D.K. Mohanty and regional government has appeared for the opposite parties number 1. So in terms of the this petition spending is supposed to.
No, till disposal of the representative status quo in respect of the plots.
The report you are relying, it already states that the person 4 and 5 is in peaceful position. How does
Yes, that's why I'm saying status quo.
4 and 5, you are coming for the 4 and 5.
I have seen
Without hearing the
What is the
multiplication
everybody should know that what will be the consequence of that.
That's why I'm saying status quo. If they are in possession, I'm not saying that
be in the position.
status
Immediately file this order.
only to status quo in respect to the allegation, madam.
We do not know whether at all the 4 and 5 is still in position today. We do not know.
Without hearing the private opposite parties, it's not desirable to pass any interim order. In item number 7 and 8, 3 copy of the order may be. 7 and 8
of the order.
Item 9.
So kindly see the last order. No, today I have submitted the instructions which I have received from the department.
What is the instruction?
But I am also filing affidavits that when the regular president is concerned, the process is on. And so far as appointment of officiating president is concerned, because that provision which has been relied upon, my instruction is that is applicable for in respect of casual vacancy, but here is a case of regular vacancy.
No, this is also a case. Somewhere already we are passing this judicial order.
But Bella, kindly bring on record, I am filing the affidavit in support of petition number 1 is the senior most.
No, they are not disputing that aspect of the matter.
Only Milad to bring to a lot of notice.
Why are they disputing among themselves with the senior?
No, I felt it necessary that I should bring.
Why you felt it necessary?
Because in respect of that, though it has been submitted a requisition document has not been filed.
Are the members disputing? Because the members are filing this.
No, they are not disputed.
We only say the senior most, this member will be take over. That was not.
I'm grateful your lordship rightly appreciated. That was.
What is their notification?
Pardon?
Their notification, appointment notification is not there.
Well, here the selection list.
This is the selection list.
Yes, yes. The appointment was given.
It was not supposed to be in your custody, mister. I'm sorry to point out. This is an internal communication between the selection committee, whereas the High Court judge was presiding over the matter.
Yes, yes.
This is a very confidential document. You are filing with an affidavit.
Since they are the members of that.
They are not supposed to get this copy.
That I cannot say.
You cannot say.
No, my lord.
Suppose, suppose as a selection committee has the proceeding and that copy is with you. I am asking you how you procure this copy. That's not fair.
Lots of return it back. Lots of return it back.
Return it back. Okay, take it back. Yes.
At least your lordship could know this.
My lord, can I tell your lordship something?
No, Lord Advocate General.
Not on this, not on this. This is on something else. Chief Justice Sujit Barman Rai was presiding a bench as Chief Justice. And in a very contested matter, one document was given to in a matter. And Mr. Arun Jaitley was in the other side. So we had tendered. He said, this document can't be looked into. It's not a part of the record. So he returned the document. He said, no, I'm giving it back. And after 15-20 minutes, he looked at him. He said, Mr. Jaitley, I have seen that document. It is only imprinted in my mind. What do I do about it? Sorry.
Well, that copy has been, I am going to understand that copy has been sought on them, to all of them.
All right, good. Keep it on their record.
Let's keep it on record.
Mr. P.K. Muduli Lalit, additional government advocate, appearing for the opposite party number 1, has produced before us the written instruction received from the Additional Secretary to the Government of Orissa, Food Supplies and Consumer Welfare Department. So, it appears that by the notification dated 21/7/2023, a new selection committee has been constituted. So it has been also asserted in the said written instruction. The process for selection of regular president is already under process. Stop. Mr. Mohanty, sorry, Mr. Muduli Learning Council has clearly submitted that state doesn't have any intention to interfere with the functioning of the consumers, the State Commission for Consumer Disputes Redressal. But at the same time, Mr. Muduli has brought to our notice the observation is made in the said written note dated 21/8/2023 that Rule 8 of Orissa Consumer Protection, first bracket, salary allowances and conditions of service of president and members of the State Commission and District Commissions, close the bracket, rules to 2020, lays down the privilege of the senior-most member of the State Commission who is deemed to be officiated as president in case of a casual vacancy in the office of the president of the commission. As the vacancy arose in the post of the president of the commission in the wake of demitting the office by former president, is a regular vacancy, comma, the senior-most member of the state commission was not supposed to be declared as the officiating president, keeping in view of the ongoing selection process for the post of the president of the state commission. Stop. It has been clearly stated, despite the position by the department letter number 11978 dated 27/2023, the senior-most member has been allowed to preside over the bench, allowed to quote, unquote, allotted to him. Stop. The reference to the bench, we must clarify at this juncture, is the bench usually presided over by the senior-most member in the state commission. And this is not officiation in the vacancy of the president. Stop. Mr. Muguli Learned Council has submitted that the rule doesn't permit the senior-most member to officiate in the regular vacancy of the president. Stop.
That is also the instruction.
Huh?
That is also in the instruction.
I'm going to have recorded your full instruction. Yes. A copy of the instruction is produced before us, is taken on record. Stop. Mr. P.K. Mohanty, senior counsel appearing for the petitioners, has submitted that it was expected from the 8 that they should appoint the new presidents beforehand, so there is no such vacancy arises. Since it has not been done, the commission cannot be allowed to be run in absence of the president. Stop. Having appreciated the submissions of the council for the parties, we direct the senior-most member, we direct the state opposite parties to allow the senior-most member to officiate the post of the president, State Commission for Consumer Dispute Redress. What is the name of the commission?
State Consumer Dispute Redressal Commission.
It is State Consumer Dispute Commission.
Disputes Redressal Commission.
Dispute Redressal Commission. Orissa. Till the new president takes over. Stop. This order shall not create any precedent because this has been passed as a stopgap arrangement. In terms of the above, this petition stands disposed of.
So, a copy of the order so that I can communicate.
The order be furnished to Mr. P.K. Muguli and council for
If it is in course of the day, so
in the course of the day. You know the order. Yeah. In the course of the day.
But they want, no, they are not relying upon my letter. They want my lord's order.
No, call a selection committee meeting forthwith. Select someone.
No, that is continuing.
I don't know what is their continuing. Meeting the selection is made.
That is as per the Supreme Court judgment. It is a process of recruitment and the rating and interview. The retired honorable judge who is going to sit in the rating and interview, that is a difficult task. Even for the post of embarrassing situations. But how about Supreme Court has done?
You being embarrassed. Judges are not embarrassed.
I don't know. For our bench,
this is a transparent method. You should not feel to be embarrassed. Okay. If someone want to be engaged, he can follow the selection process. There is no question of embarrassment. If someone feels embarrassed, he would not appear before this selection. That's all.
The retirement, nobody will want to go for any retention. That affidavit I did not return back. Let it be kept on record.
We are not taking any cognizance. And just reward your client.
No, no, my lord, it was given to them. I was instructed.
I'm confident enough that was not given to them. They have just taken out of their file, which is their custodian now for the private use. If you go more, I will just observe certain adverse comments about their conduct that I'm not going to do there. All right.
Whatever justice is expected that your lordship deliver. We are not going to that.
All right.
Item number 10.
May I please, your lordship?
That may kindly you may.
What is your annexure 5 and annexure 6?
My lord.
Annexure 5 and annexure 6.
But file has been misplaced, my made. Can you lordship will call next week?
Problem is that they are finding it difficult to determine which order you are actually challenging. As per 5 or 6, because the limitation is a very important factor.
My next week you also may call this.
31st of August 2023. Meanwhile, the appellant shall remove the doubt as expressed by the registry in their note. You go and meet the concerned superintendent of this section. He will advise you and accordingly do, because otherwise it will be a very difficult task.
Item number 12.
Actually, item 12 of Mr. Palak may kindly recommend 2 weeks later.
That will be listed on the 27th of September.
Mr. Kara, one moment.
देखले फाइल टा देले
The earlier material, Mr. PC.
Please look for your petition and examine it carefully. You filed a writ appeal, you have annexed an order of 2021 and there is no annexure 5 and 6, no annexures in the writ appeal. So please check.
And I will look into the matter. No, because these are not there. That is why I'm asking you, where is your annexure 5 and 6? It's not, you have mentioned in the body of the writ appeal.
But it has not been annexed.
But these are not available in the memorandum of appeal. That is why I'm asked you go to the superintendent and give you a list and just remove the defects. Yes.
Item 12, my lord, this United by CI and other ministry in opinion number 14. A copy may be, sir. We don't have a copy. I just from LMS I came to know that this proper opposite party is Union of India, opinion number 10 and 14.
No, you have not been served.
Copy has not been served.
Serve the copy in the meanwhile.
Yes, your lordship.
The petition is directed to serve the copy on the Mr. P.K. Pari, learned Deputy Solicitor General of India.
SR was to be made, but second copy not filed, so they have not
Is
done.
appealing for the
Number 10 and 14.
10 and 14, yes. Number 10 and 14. You supply them a copy. Mr. Pari is there.
Yes, your lordship.
SR has to be done, it has not been done.
And also remove the defects and objections in the meanwhile. In the meanwhile, the defects and objections shall be removed by the petitioner. Yes.
Item 13.
Obliged.
Now, item 13, your lordships have already issued
In
notice
this case, my lord, I am
delay and also in the main matter.
in this case, I am appearing on behalf of the respondents, my lord. I have filed an objection on the delay condemnation petition, my lord.
All right.
There are 300 days.
252 days delay.
232 days delay, my lord. I have mentioned so many judgments of the Honorable Apex Court, my lord. Here to explain the each day of delay, my lord. But they have not mentioned any valid ground for filing of the writ appeal, my lord.
Yes, Mr. Behra, what was your submission?
My lord, in the IA, we have stated that till December, my lord, there were consultations in the department, because every writ appeal has to be filed only after sanction is obtained from the law.
That is he is making a serious allegations that you have not given the details. How much time and where the matter was stuck up. You just simply cannot say before a court when some serious objection is taken, we are bound to follow the principles of law.
Your lordship may permit me to file a fresh limitation application.
Not fresh, you file a better particulars.
Your lordship.
Otherwise, this petition will be dismissed, I am telling you. At the request of Mr. A. Behra, Learned Counsel, let the matter be listed on 26/11/2023. Sorry, 26/9/2023. Meanwhile, the applicants are permitted to file the better particulars and explaining the delay. Stop. Today, the opposite party number for whom you are appearing, or the opposite party has filed the objection against the prayer for condonation of delay, stating that the petition for condonation of delay is bereft of any explanation. Stop. And it says that should be dismissed without any further consideration. Stop. Let the matter be listed. So date has been given on the 26th September. September. Stop. If by this time, by the next date, better particulars explaining the delays are not filed, we will decide the matter on appreciation of the said objection. Mr. G has said he has appeared for the opposite party.
Item number 14. Item number 14.
14 is a state appeal, I think.
So 14, there is a delay. So I filed an application seeking condonation of delay.
Yes.
14. Collector.
Who is appearing for the appellant?
I am appearing for the private respondent.
Sharma, Mr. Bigyan Sharma is for the appellant.
You are for the appellant for the state?
I am for the appellant, madam. Here the collector, being the president of the school, my lord, has filed this case, madam. Appeal. Okay. Collector was opposite party in the writ petition.
I think we have not issued any notice on.
No, my lord. The first time it has been listed.
I have been instructed to appear on behalf of the private respondent, my lord.
Yes.
And in similar cases, this Honorable Court, my lord, the very same issue has been decided, my lord. Kindly see the order.
That's a merit, my lord. Now the delay.
No. So can you see for a moment? On the merit, it has been decided in similar case.
We are on delay condemnation. We haven't reached the merit stage.
Yeah, but
have you seen this order? Just see this order. Because in a way, actually, it allows you writ appeal.
But 2013 rule has been applied to a person who was appointed in the year 2010. 2013 rule will have prospective in operation. So if you are relying on 2013 rule,
where he passed the order of termination?
2007.
2017.
So,
how 2019.
How the rule before 2013?
But the appointment was in the 2020.
Mr. That is another thing.
The rule says if its appointment is made in pursuant to sub-rule 2 of rule 5, then they have the all this security, my lord. Yes. He has not been appointed under sub-rule 2 of rule 5 of that particular rule, my lord.
All right. Do you have any objection if you condone the delay?
Delay condemnation petition and appeal may be served on me. Today I entered my appearance.
All right, then I issue notice. In I number 1902 of 2023, Heard Mr. Vigyan Sharma and the counsel appearing for the applicant. This is an application in section 5 of the Limitation Act for condoning delay. Of 222 days as per the stamp report. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders shall not be passed in the circumstances of the case. Notice is made returnable on 14th of September 2023. Since Mr. G.S. Sethi, Learned Counsel, appears no whips notice for the opposite parties number opposite party number 1. And Mr. who is appearing for the state, Mr. Kuntia or Mr. Muduli, in this matter, you are the pro forma respondent.
Yeah, Lord, sir. I'm appealing.
Mr. Arnav Behra, Learned Standing Counsel, appears for the pro forma respondents number 2 and 3. And with notice, no formal notice is called for. Mr. Sharma, Learned Counsel, is requested to furnish the copies of the application and the memorandum of appeal in the course of the day to the Learned Counsel appearing for the opposite parties. Stop. By the next date, the objection, if any, shall be filed by the next date. No further accommodation will be made. Stop. Let us see it come on 14th of September again. Keep it up. Fine.
It will be on 15th, Lord. Let it be on 15th or 13th.
15th is a Friday. 13th. Let it be on 13th.
Item number 15. My pleasure. Two eyes are there. One for dispensing with, another for condonation of delay. 127 days delay, my lord.
Anyone is appearing?
My lord, I am for the respondent. My lord, kindly have a glance to the order, my lord. Order of the writ. That is, my lord, dated 13/11/2020.
The first thing first, that whether are you opposing the delay?
My lord, already the matter has decided and they have not complied with the order.
These are all on merit. These are all on merit. Let us condone the delay. Here this appeal today itself. If you say it is already been decided.
Yes.
Because delay is very short delay. It is, oh no, it is a 252 days delay.
127. My lord, it is.
The SR says it is a 252 days delay.
The order was passed on 13th.
Oh, I am seeing 13.
5 and 23/11/2022. So 1 month time.
Not 30 days delay. Would you like to file any objection regarding the limitation? If you say no, then we can take up the matter on merit. Right now.
Yes.
Delay may be condoned. So let Mr. Kumthir then take up the matter. Just IM 2299 of 2023. Heard Mr. M.K. Kuntia, Learned Counsel, appearing for the appellant's application. And your good name, sir?
Okay, Jena. A.K. Jena, my lord.
And Mr. A.K. Jena, Learned Counsel, appearing for the opposite party. So this is an application for condoning the delay of 130 days in preparing the appeal, in preparing the interpret appeal from the order dated 23/11/2022 passed by the Land Civil Judge in WPC number 6076 of 2022. So, Mr. General Learned Counsel at the outset submitted that we will not oppose the prayer for condonation of delay because the appeal is covered by a decision of this court, right? We have also perused the causes assigned in this application for explaining the delay. So, message. We condone the delay. And the result of this application is allowed in this poster. In view of the order passed in I number such and such. This appeal, this appeal has been taken for consideration. Yes, Mr. Kumtia, what is your submission?
Yes, ma'am. Let's turn to annexure.
What is the decision of this court? Do you have a copy?
No, my lord. Writ appeal copy I have not.
No, not the writ appeal copy. The decision of this court. That
Yes, my lord. That is in my.
You just have to give a copy to him.
No, but he saying I don't understand also how it is covered. How it is covered?
My lord, the order of the writ application that is on 23/11/2022. My lord, on that writ, the order has passed on the basis of Malayananda Sethi and state of Orissa, and this is for rehabilitation assistance. My lord.
Reasoning.
So on that basis,
if this matters have been taken in the next date,
yes, what has happened, my lord? This case is not covered by that. That case is not applicable to the facts and circumstances of the case. What is the ratio decided in that Malayananda Sethi case? Your lordship has rendered a judgment on the relying that Malayananda Sethi, the date of application or the date of considering the criteria for to be considered in accordance with the 2020 rule or the previous rule.
Yes.
This is a case, my lord. He has approached my lords earlier, and your lordship are directed to consider his case. And we consider his case and rejected because for rehabilitation assistance scheme, 2 persons are claiming for appointment under rehabilitation. The mother is applying, mother has applied and son has applied. Accordingly, we have rejected their case. He is no way related with that Malayananda Sethi case. But the honorable
why have you not given any one of them?
Because 2 persons have applied and perhaps one is not, mother is not coming within that for the 2020 rules. He has applied in 2021. So his well covered on the 2020 rules. And the son has come and has approached my lords that to give him appointment under rehabilitation assistance scheme. And your lordship are directed to consider his case. That in consideration of his case, that was rejected.
Then the second writ petition.
Second writ petition has been filed, and on the very first day, that order has been filed and direction has been given to consider his case in accordance with the Malayananda Sethi case.
Or it will take up.
Let me clarify, my lord. That
Yes.
part. Yes. Mother has applied. That part has been cleared in the writ application, my lord. That is a mutual.
Just supply because.
Yes, I will supply.
Do you have already a copy of the?
I am giving that copy.
All right.
Yeah, my lord, the disease has 2 wives.
You come at 2. Both of you. Just you take the memorandum of appeal. Come at 2.
Yeah, after plans, 3 matters are there. Your lordship can fix.
No, after that, we just try.
Your lordship can fix it to tomorrow so that it can be.
All right, only tomorrow. Come
Yes,
tomorrow.
yes.
Appeal tomorrow. Huh?
Date chart will come.
Just you prepare a date chart and we will come.
Yes, yes. I will
Full preparation.
I am serving a copy.
Yes.
Yes.
Item number 16.
Okay.
16, my lord, there is a delay of 273 days.
All right. In I 3875 of 2020, there's an application as 5 of Limitation Act for condonation of delay. According to the stamp report, there is a delay of
335 days.
335 days in preparing the intercourt appeal from the judgment from the order dated, so 5/7/2022, possibly the last signatures in WPC within first bracket, OAC, close the bracket number 3068 of 2014. Heard Mr. Arnav Behral and Mr. National Standing Counsel, appearing to the applicants, stop. Issue notice as to why the same way, why the delay shall not be funded. Notice is made returnable on 20, just given October. 4th October 2023.
Your lordship may permit me to file an additional affidavit explaining the delay.
For the time being, we are filing it because this is a practice I am pointing out from the day one. This will not be there. So otherwise, you just file a fresh petition that also can do because I recall the order of notice I have issued. Otherwise, you make a formal application for amendment of the application.
Then I'll withdraw the invitation application. I'll file a better application.
All right. Just go out. Mr. P. Beral and Additional Standing Counsel appearing with the applicant at the outset submitted that he would withdraw this application for condonation of delay. For filing a fresh application for the same purpose, rest and sell out. And this application accordingly stands disposed of as withdrawn at liberty reserved to file a fresh petition. Stop. Because according to the law, I have to dismiss the appeal now in absence of the limitation petition.
Then your lordship I'll file an amendment petition for your lordship.
You're so confused. File an amendment petition.
Your lordship.
The outset has submitted that. He may be permitted some accommodation today for filing an amendment application, seeking the amendment of these interlocutory application. There's a loan that to be listed on 13th of September 2023. Next.
Item 17. There's a delay of 195 days.
Just change.
I have instruction to appear for the respondents, my lord.
All right. Item 18.
17, my lord.
You will file the objection
to delay. No, my lord. The delay may be condoned. The matter may be heard finally because the petitioners was the respondent was of the retirement, my lord. It's a regulation matter.
All right. Well, Mr.
Today, item 61 is similar. Your lordship will take up the matter at 12:30 regarding regularization of daily wage employees.
All that will fix the appeal will be taken at 12:30.
Your lordship.
We condone the delay here. Or Mr. Arnav Beral and Counsel. Additional Standing Counsel appearing for the applicants/applicants. This is an application for condoning the delay of 194 days in preferring the intercourt appeal from the order dated 12/12/2022, passed by a single judge in WTC number 11392 of 2021. Mr. K. Swine Leonard Counsel is appeared for. You are appearing for all the.
Yes, my lord.
Appeared for the respondents number 1 to 7. The file the Vakalat number?
Yes, my lord. In course of the day, I will file, my lord.
And he has stated that he will file the power executed by those opposite parties in the course of the day. So, who is appearing for the other respondent? Mr. P.K. Muduli. This is a pro forma respondent state. You just appear. Mr. P.K. Muduli Lanet, additional government advocate, appears for the pro forma respondents, opposite parties / respondents number 8, 9, and 10. So, Mr. Muduli has categorically stated that they have no conflicting interest with the applicant applicants. Mr. Swine Leonard Council, appearing for these opposite parties number 1 to 7, has stated that the appeal concerned with regulation of these respondents, he represents. So he has instruction not to oppose the prayer for the condemnation so that the appeal can be heard expeditiously. Stop. In view of the above statement made by Mr. Swine, also considering the amendments made in this application, we find that the applicants have made out a case for condonation of delay. Accordingly, we condone the delay, and the result this application stands allowed in this post of. So, in view of the order first, just we'll take the appeal also at 12:30. 12:30. Mark it as at 12:30. But they are at 12:30.
Right, a copy is out upon me, Melody.
Yes,
Right away.
Copy.
Item 18.
Also, Your Lordship, there is a delay of more than 360 days.
The order that you have scored earlier, what order? We have scored the full order. That you just take this number. There is one petition for the dispensing also.
Your Lordship, we'll file a certified copy.
There is a 4743. There is a delay. Just change the delay. Arnav Behra is the same lawyer. There will be no difficulty. 364 days delay. And for filing the intercourt appeal from the order dated 29/6/2020 by the possible signatures WPC number 12912 of 2022. In IA number 4742 of 2023, Mr. Arnav Behra and his Regional Standing Council appealing to the appellant applicants. There is an application for dispensing with the filing of the certified copy of the impugned order of the impugned order dated 29/6/2022. Surgical and Civil Judge in WPC number 12912 of 2022. Mr. Behra has stated that a photocopy of the said order, Annexure 1 to the Memorandum of Appeal has been filed, as there was urgency in processing the appeal to avert serious legal consequences. They could not obtain the certified copy within that time. Be that as it may, we allow this application by dispensing with the requirement of filing the certified copy of the impugned order dated 29/6/2022, subject to condition that the appellant applicant shall file the certified copy forthwith. In terms of the above, this application stands allowed. You file the certified copy.
Yeah, sure. Before the next date.
Yes. And take steps within 3 working days to make it. It will come on the 27th of September. No, it's the 4th of October. 4th of October.
Item 19.
On 19, I found from the coordinate that the respondent has already entered appearance by filing caveat. I'll serve the copy of the writ appeal along with the IS. By tomorrow, I'll serve on the caveat.
You are for the caveat. Mr. Durgesh Narayan.
Amit Kumar, sir.
Oh, Mr. A.K. Blood Council has appeared for the caveat. Mr. Muduli Lanet, P.K. Muduli Lanet, Issue Government Advocate, submits that he will serve the copy of the November of appeal along with the miscellaneous applications to Mr. Sai in the course of the day. By tomorrow, all right, by tomorrow, where the matter will be listed on.
There is an urgency next week,
Next week, what can date? You would look at the number, give the date only. 30th August 2023. Since Mr. Shah has appeared, we discharge the caveat in the result. The caveat petition number 128 of 2023 is disposed of.
Item number 20. So though there is 100 odd days delay, but it's a pending matter. And since the Honorable Single Judge has passed an order for placing the matter before any other bench, so that prompted us to file because the interim order is continuing against us in a pending proceeding before the before the NCLT. So, if your lordship,
what is your reverse?
Yes, my lord.
How this can be the subject matter of a appeal?
My lord, in the writ petition, if your lordship should just see the prayer in the writ petition, what has been filed. That is, Lord, which is at annexure, it starts with annexure page 31, the prayer portion. I'll just. The Lordship should come to page 69. Chief. Because there are two CPs which were filed, one by the same applicant. The first one was under section 241, 242 for operation mismanagement. And we filed an objection on the maintainability.
69 is an affidavit.
No, my lord.
It must be in 68.
Then your lordship maybe 67 then, maybe because.
Right.
Maybe the paging
is. Really, the prayer starts from page 65, I think.
Issue a writ in the nature of prohibition or certiorari, if your lordship said.
Yes.
In your order, writ orders directions to respondent number 1, NCLT, directing to hear CP number so and so 11 of 23 with or before pronouncing an order CP number 44 of 22. So the procedure wanted to be laid down before this honorable court so far as the NCLT proceedings are concerned. And this CP number 44 of 22 on the application that we have made regarding the maintainability, the matter has been heard on merit and judgment has been reserved. And subsequently, after the filing of the petition, when they filed the objection, they came to know that there are certain defects for which the 241-42 application cannot be maintainable because they are not members or registered shareholders. So they wanted to cure that defect by way of filing the subsequent CP under section 59 of the Companies Act regarding registration of the members.
Yes.
So they want that petition to be heard first. And for that, they have come before your lordships, before the Honorable Single Bench, and taken an order which has stayed the proceeding in that CP 244, which is that original application of 241-42.
Your anxiety is that matter should be heard expeditiously. That is the whole anxiety, I think.
No, but the only problem is now the order cannot be pronounced by the NCLT. And they are insisting upon hearing of this subsequent application. So if a lordship stays both the applications, we have no objection because it has to be
about both the petition. That we cannot do, because we can do one thing, that if the learned single judge is recused, we can just place the matter before any other bench. That will be, I will take up in the administrative side. Right. Dismissing your petition on the ground of limitation. All right. No, on the ground of limitation, because it's a huge ground.
123 days, but that was occasioned because the recusal of the Honorable Single Judge, otherwise the matter was very heard.
Mr. D.P. Nandal and Senior Counsel appearing for the applicant. Mr. Nandal and Counsel has stated that the grievance in the writ appeal emanates from the order dated 17
March 2023.
So, that is the order.
Yes, no, that is, your lordships may see page 29. That would be 27 in your lordships, might be brief. It's 2 pages.
Which is a notice by which the notice was issued on the opposite parties, number 2 to 6.
The IUD interim order has been passed, which is at page 20.
Along with the said order,
28.
In the IA numbers, an interim order has been passed directing the
NCLT.
Directing the NCLT prohibiting the NCLT from pronouncing the judgment till the next date of listing. Stop.
Well, more agree is the subsequent, the next line which has been passed by the Honorable Single Judge.
So it has been observed by the said order dated 17/3/2023. Further, that it is made clear that the tendency of the writ petition shall not stand as a bar in hearing the other miscellaneous application in the meantime. So, according to Mr. Nandal, Learned Counsel, the 2 observations are not congruous in nature. And that is the reason why they have filed this appeal by challenging the said order dated 17/3/2023. So, this is an application for condoning the delay of 142 days in preferring the intercourt appeal from the said order dated 17/3/2023. And the delay is of 124 days. So, having considered the merit of the challenge, we are of the view that this is not a case we shall condone the delay. So, and accordingly, the application for delay stand dismiss next in the main application. As a consequence of the order passed today in IA number such and such, the main appeal is dismissed. However, this matter be placed for the appropriate administrative order. Why is the order of recusal?
It is on 4th August that has been passed, the order. We have not filed it. I'm sorry.
As it has been stated by Mr. Nandal and Senior Counsel that on 4th August, the learned single judge was recused from the writ petition. All right, that will fix the matter before another bench. You just want to do 4th August that order, just take it print out and send to the.
My lord, one line if your lordships can just add. Today the matter is listed before the NCLT so far as the other application is concerned. if we can be given the liberty to move an application for adjournment, that may be heard on its own merit, because the matter is to be heard.
The appellant will be at liberty to make the appropriate application. Will the NCLT?
NCLT, Cuttack bench.
NCLT Cuttack bench. All right. All right, this
is seeking adjournment on the ground of the pendency of the writ petition.
No, that I will not discuss. You can file an application.
All right.
That will be interception.
No, that's all right. That itself will also be helpful for us. That itself will be helpful for us, my friends.
14th August, not 4 August.
Oh, I'm sorry, my friends.
4 August 2014. Because
I'm so sorry.
Just send the recorder to RG, no? Not RG, but rest of judicial. Next.
Item 21. In all these batch of writ petition for us, challenging the petitioner to legality and validity of Section 2G of the Orissa Income Tax Act. Because even though facts may vary from case to case, but in all the cases, the central dispute is challenging 2G of the Income Tax Act. Because before I take my lord's attention to the provisions, yes, one of the lead case, facts involved in the lead case, let me place, so that we can apply law.
Please, item number?
Item number was the first matter, WPC number 21892 of 2012. The first matter.
WPC number 21892 of 2012.
This is Hindustan Petroleum Corporation Limited versus State of Odisha.
All right.
Yes, I will straightway take my lord's attention to page 53. Yes, this is an order of assessment, and in the order of assessment, your lordship will find out that based on the audit visit report, the assessment framed how they have dealt with the 2J. While dealing with 2J, how they have dealt with the facts below. That is observation number 4 at page 53. Now, Milas, before I take the lordship's attention to table, Milas, the brief facts of the case is that petition before lordship, Milas, he has refineries in the East Coast and West Coast, one at Bombay and Visakhapatnam. Plus, they get crude oil, get it refined in the refineries, and from the refineries, plus refined petroleum products are transported to different states. Plus, in this state of Odisha, we have different branch locations where goods are transported, and we receive the goods here for distribution at our end. And the goods which are transported from refinery, that is accompanying with a very important document called RTP. It's a stock transfer invoice which contains RTP refinery. Plus, this price is called transfer price. That is the price which includes transportation and also the cost of goods. Excise duty, all this. Plus, what has been done in this case, two different modalities are adopted for the purpose of valuation, for the purpose of levy of entry tax. What are those bills? What I bring bills is MS. MS means motor speed, that is called petrol bills. Then HSD, high speed diesel. Then LDU. Then SKO means kerosene oil.
Yes.
FO. ATF, aviation turbine fuel. Then lubes, B2, bitumen and LPG. Well, these are the products which I bring bills. Now I take your lordship's attention to the table bills. How bills, in what manner bills they have calculated for the purpose of valuation for entry tax bills. My lordship kindly see period they have mentioned. We also pay skip 1/10/2006 to 31/3/2010, covering the period of assessment. Goods bills, as I described, these are the goods. Then quantity received from branches outside Odisha. These are the quantities received gross. Then value of receipt in rupees. This is the corresponding value of the different products which I have received. Then my lords may kindly see this, from this my lords may kindly have a comparison. Average receipt value rupees per unit. That means MS means petrol. Yes. Petrol per liter price is 37.20. Of course, that is at that point of time, not today. In 2005 to 10, the receipt price was 37.20. Now, quantity sold in Odisha, you will also skip quantity sold, you will also come down straight to the average sell price. That is at column number 7. Your sell price is 37.33. I received the receipt price is 37.20 and my corresponding sell price in Odisha is 37.33 per meter. Yes. Then differential value I have mentioned, plus. Some are reflected plus and some are minus, plus 13. And this is the differential amount minus. Similarly, let me first place minus, then I will. Then HS diesel 30.18 and the sale price is 28.67. That means my receipt price is low, my sale price is less. My lords may kindly get it.
He's only in 3 items, this has happened.
Exactly, correct. HSD, SQ, kerosene, there is huge margin difference. Kerosene receipt price is 18.72 and I am selling at only 8.97. Let me have a break here. Yes. So why do I sell at such a abnormal low price? Because it's a commodity, the price of which is left to be determined by the state because it's a controlled item. It is sold through fair ration shops, and because the poorer people, they use it as fuel for cooking. So therefore, government has to, it's at the government level to decide the price for us. I have also a government of India taking us for the benefit of the poor people for us. Whatever government decides for us, accordingly we are selling the goods for us. So therefore, we receipt value is much more and we sell at a very lesser price. Now, leaves also same thing. I will write you also from 120 it is the receipt price. I am selling at 91. Then kindly come down to last item, LPG. So the LPG gas mirrors is of 2 types. One is for domestic use, other is for industrial use. Exactly. Now, my lords will kindly see column number 7, LPG. In the left-hand side, your lordship will find from column number 5, cylinder domestic, 14.2 kg of cylinders. This is for domestic use, brothers. Price is 20.70. And kindly see the sale price in Odisha, 403 crores, 32 lakhs, 28 lakhs, 341. Now, kindly descend to the next serial. That is, the next line is industrial was 19 kg. 19 kg, IND stands for industrial. 19 kg cylinder, unlike the domestic cylinder, 14 kg. Here my sale is 41 crores, 50 lakhs, 24,724, and the price per kg is 41.41. So my loss will find it is 10:1. If I will out of 100%, 90% sales is domestic cylinder, 10% is yours industrial cylinder. Yes. Precisely, maybe little more or less. Then kindly come down to last.
Going to this such meticulous details of the statistics. What is the purpose? This question is very simple.
Only last sentence. 31.05 kg average. Here your lordship will find how they have derived 20.704 kg and 41.410 kg. They mixed up the two amounts and found average of 31. If they find average of 31, then the 20 rupees which I am selling domestic.
That is why you come straight to that point.
Yes.
How these are the price can be treated for these categories of cylinders.
Absolutely correct. That's the whole intention here.
Why you are making this average?
Next case.
2J say the price.
It's
52 does it derive the sale price which is the actual sale price?
Just to make it confirm, your lordship, in the second case, your lordship, I will argue, the second case is also of my learning senior, and their table, your lordship, will tell something different, your lordship. Because how much the difference and why this, what is the intention of the relationship to insert this proviso of section 2J, your lordship, from part second case, your lordship.
in order to justify that action, in order to justify the action of the legislature for insertion of that proviso, this differentiation has been made by your Lordship, the assessing officer.
Okay, my friend, that's the whole thrust is not that. Whole thrust is what they have done. Where the sale price is less, they have taken the receipt price. Where the sale price is low, they have taken the sale price to be the basis of calculation. I think I am intelligible to explain what you know. I will also found in 3 places where the sale price is less than receipt price. They have, instead of taking, because if at all, without prejudice to what my friend says and without prejudice to what my Lord will take ultimately decision, 2J, they, according to them, 2J speaks of market price. According to them, that's the modality they have to resort to.
Yes.
Now, even for a moment, if they at all go for, there must be uniformity. You can't choose, pick and choose 3, where your receipt price is more, sale price is less. You will accept receipt price to be the basis. And where the sale price is more, you will consider sale price to be the basis. That is how this has, and in the process, they have already 150 crores to buy turnover for the purpose of levy of tax. This is the modality they have accepted. Now let us come back to 2J.
But you have not challenged section 2J.
Exactly. That is how we for also gloves. All the repetitions.
Just read the prayer.
Yes, prayer number 2, issue rule I see to the project part as Y. Provided to section 2J of the AET Act shall not be held illegal, unconstitutional, ultra vires section 2D, E, F and section 3 read with entry 52 leads to 7th schedule of the Constitution of India. And order dated so also passed by OP number 3 by annexed so also.
Consequential order.
Yes. So that one you have challenged me also.
I fail to understand how you are also challenging the section 2D, E and F. And the section 3 read with entry 50.
Yes. This 2J, according to my mirrors, those ultra vires other provisions of the same enactment. And also entry 52 leads to 7th schedule constitutional mirrors. But how is it so? Your Lordship, I kindly see 2J first mirrors. 2J. In fact, 2J doesn't hit us all the provisions provided to 2J. That is what the substantive provision which you understand for Lordship. Section 2J. This is a definitional provision.
Yes.
It defines the expression purchase price. Purchase value. Purchase value.
Yes.
Yes. Because purchase value means the value of scheduled goods as ascertained from original invoice or bill and includes insurance charges, excise duties, countervailing charges, sales tax, value-added tax, or as the case may be turnover tax, transport charges, freight charges, and all other charges incidental to the purchase of such goods. Because your Lordship kindly underline the expression incidental to the purchase of such goods. Now, next your Lordship kindly come to provided that where purchase value of any scheduled goods is not ascertainable on account of non-availability or non-production of the original invoice or bill, or when the invoice or bill produced is proved to be false, or if the scheduled goods are required, this required is a wrong, it must be read as acquired. It's in fact a wrongly printing mistake. But anyway, are acquired or obtained otherwise than by your purchase, then the purchase value shall be the value or the price at which the scheduled goods of like kind or quality is sold or is capable of being sold in the open market. Plus, almost all the cases before Lordship in this batch mirrors concerns this when the scheduled goods or if the scheduled goods are acquired or obtained otherwise than by your purchase, yes, the consequences are here. So almost all these cases mirrors almost are pertaining to the issue when the goods are acquired or obtained otherwise than by your purchase, then to what effect? So that's the question mirrors. And as per the proviso, the consequences exactly legislature is here. that it shall be the value or the price. My lords will also see the connotation, value or the price at which the scheduled goods of like kind or quality is sold or is capable of being sold in open market. Admittedly, there is no corresponding rules. Even if Rule 34, Section 34 provides the state, endows power upon the government to make rules, but no rules have yet been framed. And the rules which is already available for making provision for this is Rule 17. That doesn't deal with this. That speaks of something else, but that doesn't deal with how to develop the modality that is given in Section 2J. It is not there in Rule 17. Rule 17 only says where the documents are produced in respect of this goods, and if it is found to be false, then an opportunity given before it is rejected. They have power to reject also. And in this case, whatever RTP, I will refinery transfer price, transfer note, stock transfer note, they are not rejected also. In my case, even pertaining to complying Rule 17, because they have not rejected. But they have accepted this modality to find out the value, and accordingly they have gone for adding 150 crores per review of tax. Now you also kindly see some relevant provisions before I take your lordship's attention to the judgment. Some relevant provisions should also kindly see. That is Section 3, the charging provision. Your lordship must have to say this. Section 3, my lordship kindly see for a moment. Yes. Section 3 deals with the levy of tax. There, subsection 1. There shall be levied and collected a tax on entry of the scheduled goods into a local area for consumption, use, or sale therein at such rate not exceeding 12% of the purchase value of such goods from such date as be specified in the state government, and different dates and different rates may be specified for different goods and local areas subject to such conditions as prescribed. Provided that the state government may direct that in such circumstances and under such conditions and for such period as may prescribed, a dealer shall pay in lieu of this composition. You will find Section 3(1) precisely a reproduction of entry 52 leads to 7 scheduled constitution. That is, entry of goods into a local area for sale, use, sale, and consumption inside. Then 2 dealers. 2 is the person identified who is liable to pay tax. The tax levied under this act shall be paid by every dealer in scheduled goods or any other person who brings or causes to be brought into a local area such scheduled goods, whether on his own account or on account of his principal or customer or tax delivery, or is entitled to delivery of such goods on such entry. These are the persons who are liable to pay tax laws. Provided that no tax shall be levied under this act on the entry of scheduled goods into a local area, if it is proved to the satisfaction of the assessing authority that such goods have already been subjected to entry tax, or that the entry tax has been paid by any other person, this prevents multiple levy on the same goods. This is how. Subsection 3 I need not, because that has been deleted subsequently. It speaks of motor vehicle. Yes. But let me also not to say anything contained in subsection 1 and 2, but subject to provision of this act, there shall be levied and collected a tax on the entry of any motor vehicle into any local area for use or sale therein, and liable for registration in the state of Odisha under Motor Vehicle Act, and the rate of tax shall be at such rate or rates as be specified by the state government by notification on the purchase value of such motor vehicles. Explanation by the review or doubt are declared that any scheduled goods have been subject to levy of octroi under the Odisha Municipal Act prior to commencement of this act. For entry into local area, those goods shall not be subject to levy of. This is to avoid multiple levy laws. Yes. Now, Milas, let me kindly turn to Milas, Section 4. That has been deleted, but at the relevant time this was enforced. Your lordship will find from the footnote, Milas.
No, this is deleted, but what is the old section?
Old section, your lordship will find from the book at the bottom, Milas. Footnote. Okay. A reduction in tax liability.
Same page.
Yes, yes. Same page at the bottom, Milas. Where an importer of motor vehicle liable to pay tax under subsection 3 of section 7, being a dealer of motor vehicles, becomes liable to pay tax under the Sales Tax Act by virtue of sale of such motor vehicles, there is liability under the Sales Tax Act shall be reduced to the extent of tax paid under this Act. Explanation. For the purpose of this subsection, the chassis and the vehicles with body built on the chassis shall be treated as one and the same. When an importer, manufacturer of goods specified in Part 3 of the schedule, except motor vehicle, pays tax under subsection 1 of Section 3 or Section 26 of this Act, being a dealer under the Sales Tax Act, becomes liable to pay tax under the said Act by virtue of sale of such goods, then the liability under the Sales Tax Act will be reduced to the extent of tax paid under this Act. 3. The reduction in tax liability of an importer as provided in subsection 1 or an importer or manufacturer provided in subsection 2 shall not be allowed unless the entity tax paid and tax payable under the Sales Tax Act are shown separately in the cash memo and the bill invoice issued by him or for the sale by virtue of which they are liable to accrue. That's if a manufacturer has paid tax, entity tax, because every manufacturer under Section 26 carry an obligation to pay entity tax on the goods manufactured, and if such a tax is paid, then whatever tax he has paid on the input shall be allowed to be adjusted. Similarly, in case of motor vehicle, if any tax is paid at the point of entry to government under the Sales Tax Act, that will be allowed to be reduced from the entity tax payable to find out the ultimate tax. These are provision for reduction of tax liability. Then, so important that your Lordship was inquiring the 2D. What is 2D? Yes. So kindly mark 2D. What is 2D? Definition of entry of goods.
That is it. That is why are you challenging this entry of goods?
So I am not challenging. I say entry of goods. I say that 2J alternates 2D. 2J alternates belongs to EF and Section 3, the charging provision itself. Because charging provision doesn't contemplate the manner to which 2J wants us to comply. That is not comprehended, cannot be comprehended under Section 3. Section 3 is the reproduction of entry 52 only. But this provided to Section 2J is contrary to the mandate of your Section 52 list to us. That is how we have challenged it. Now, my Lordship, kindly look into clause 2B, entry of goods clause. Plus, entry of goods with all grammatical variations and cognate expression means entry of goods into local area from any place outside that local area or any place outside the state for consumption, use or sale therein. Plus, any, then what local area means here? Plus, local area, there's a definition under 2F. Now, my Lordship, kindly.
We'll continue tomorrow.
At 2 p.m., my lords. That will be better. Because I know Lordship is done at 2 p.m. So many matters are there.
Okay.
I understand. Yes. 2 p.m., my lords. Deeply obliged. That will be better.
Heart, Mr. Such is it.
Your Lordship, tomorrow that fire and service matter is there, has been fixed, Your Lordship.
Minors have kept their fire. Then we have to go to day after tomorrow. Mr. Sahu, day after tomorrow is will be difficult.
Number 10. I'll be through. Let it be there tomorrow at 2 p.m. If it doesn't,
they say there is a series of matters are posted on that day also. What is the situation the day after tomorrow? 24th. We are fixing on 24th. Difficulty.
2 p.m. Yes.
2 p.m.
24th.
But Mr. Saul Senior Counsel listed by MS Kajul Soul and Counsel for the in part for continuation of hearing is the matter on 24th August 2023. So the interim order is passed early along with all the names. Interim order is passed earlier, shall continue.
Your Lordship, my only prayer is that in some of the cases, Your Lordship, I have not received the copy, Your Lordship. Otherwise, I am ready in all cases. But in 2 to 4 cases, I haven't received copy.
You just give to Mr. Sahu that he will organize the matter. You
Your
find
Lordship,
out,
yes, I'll
or Miss Sahu, then you find out and supply you a copy.
Yes, madam.
Complete it by.
now all the council, your Lordship.
In my case, I have no
Contact, coordinate with your-
So I'll do.
All right.
I'll-
Oh, that is why you got it.
Item 61. With item number 17 also.
70 and visit.
70.
Item 7. Oh, this, yes. That is how we are taking your matter.
Madam,
Taking your matter now.
yes, madam. Just now I have received the copy, my lord. I need some time to get myself prepared, my lord. Just now I have got this.
So,
Item 17, your lordship may fix a date anytime after two weeks.
that can be done. In item 17, we did not pass. We have passed the order into order. Who took the? SUBHASIS. Telling him to leave we have the order passed in RE number 6 itself. Combination application. You believe the appeal on. 14th September.
Madam, my only submission, the first content petition has already been disposed of with the direction to comply with the order by September. Lordship, a second content may not be pressed in the meantime.
All right, let us examine that.
My lord.
What is the contempt? Contempt we are not taking, only retaping now.
Your lordship.
All right.
Your lordship may keep the IA for stay pending.
Oh, that is pending.
Your lordship.
We have not passed any order.
Oblige, madam.
Item 61.
May I please, your Lordship?
Yes.
The appellant, after rendering 27 years of service, was not regularized, for which she had filed 2 writ petitions.
Yes.
First writ petition was disposed of with a direction that she should file a representation, press representation.
And
It should be,
they are not considered.
but it did not consider. So, the second writ petition was filed with prayer to regularize. And my lord, after the first contempt was rejected, just after rejection, the opposite party communicated an order to the appellant that because you have approached the High Court without prior permission of the authority, so your pay from February 2022 is held up. You will not be disbursed in salary.
Pay
or
from-
further orders.
After that, he did not get any pay.
Yes, my lord. He did not get any pay.
Petitioner, he or she?
See,
She.
my lord. So, the
February 2021.
22.
22.
My lord. So, she filed an IA to with prayer that her because she will not get any salary and she was in verge of retirement, so requested the court to direct that her salary should be disbursed, released. But still then, even after 2 orders, they are not released. So, the then judge in civil bench directed that the opposite party should appear in person in the court. After that order, her salary was released. But the next day, they issued another order that you are paid abnormally high amount from 17 to 21, from the year 17 to 21. So 2,45,000 will be recovered from you. So, my lord, without giving an opportunity to defend, they started recovering. So again, another I was filed in 2022 before the judge single bench.
How that by IA you can challenge that order of recovery for the excess payment they have made?
Well, because
No, how? That matter was a completely a different issue. That was relating to your regularization, as I understand.
well,
How that you can file that excess amount is a completely different subject matter.
well,
By IA you have challenged it.
no, that not been carried out also because only after that order, the writ petition was dismissed. So automatically the order in IA that the recovery should be stayed till disposal did not yield in result. So it was.
And what happened after that?
After that, the writ petition was dismissed, my lord.
Then?
The present writ, for which a writ appeal has been, this present writ appeal has been filed. My lord,
So you have not amended also your writ petition?
Pardon?
You did not amend your writ petition also?
Because that there was no time, we required.
This will not allow you to raise that challenge against the excess amount of payment. So this writ petition number 39394 of 2021. What was the relief you prayed in that writ petition? Show us. Come to the relief prayed in that writ petition.
Yes, madam.
Only the prayer is the regularization from the date of your ad hoc appointment.
Yes, madam.
12/9/1996.
Yes, madam.
On the basis of what you are claiming this relief?
Well, because she has rendered to more than 27 years of service, so she prayed that she should be regularized.
Is there any scheme of the state government to
the state government? Mr. Kuntia, the additional committee advocate, has filed enough to supply.
I have filed all the circulars guidelines for regularization. On last page in the Lordship directed by memorandum, I have filed it on 5th July 2023.
Separately or an affidavit?
By open up memo, my lord, memorandum. If your Lordship will direct me, I can file by open affidavit.
It's all right. We're finding it out.
Extra copy living.
What is this circular?
The Lordship got it on 5th, my memorandum dated 5th July 2023.
Last month.
That is not there.
May I supply another document?
Let us see whether it is there or not. Is there?
That e-filing on 5th July, madam.
All right. It is item number
61.
Where is that memo?
Maybe next meeting.
This one, flag X. All right, read that. This is a ban on recruitment in 1993.
Well,
this fact was not very material because on record it's found that she was working. Even after that memo was issued, someone has appointed her on the ad hoc basis. Why the employee should be punished for this?
No, my lord, what are the police I have given that? We have framed the policy. We have framed the policy.
These are the banning of all sorts of this kind of appointments.
My lord. But subsequent policy, your lordship has seen that page 3. That was the policy framed.
Yes.
That's got it. In some cases where your lordship are directed to frame a scheme for regularization. So in compliance to my lord's direction in different cases, this scheme was framed.
So why you have not considered this present appellant under this scheme?
She does not fall under that scheme.
Why? What is the defects?
Yes, ma'am, that LOC got it that 15 May 19.
What conditions you have made out?
Yes, Miss. Clause 2.
The worker should have been engaged prior to such and such.
My lord.
All right.
And subsequent scheme, my lord, this is regarding that engineering.
Also read one.
Yes, my lord. The subsequent scheme, my lord, in regard.
Also read one.
My lord.
You read also the clause 1.
Yes, my lord. Separate gradation oblique senior list and prepared by the applicant for each category determining the length of engagement of a particular person. The worker should have worked under the administrative control of the department concerned directly for a minimum period of 10 years. The engagement of 240 days in a year shall be constituted as a complete year of engagement for this workforce.
So he fulfills this condition.
Yeah, first condition he fulfills. Then the second condition. The worker should have engaged prior to 12 for 1990.
So the man and the officers realized his service. How can you morally argue on this point? You are supposed to be the moral employer.
Well,
you are realizing service in one hand sense, then I will not give because he was not appointed before 1993. What action you have taken against your officer who has appointed him?
Well, what has happened? They are management schools. They are appointed by the management, my lord. Subsequently, when the school is taken up, what has happened? They are appointed on ad hoc basis from time to time in 1996.
When the school was taken over?
The government school in 1994. His appointment order, first appointment order.
1994 it was taken over?
My lord. In LRC we can find it. LRC see his appointment order, engagement order.
That where is that?
That annexure 1, page 19 of the writ appeal.
Page 19 of writ appeal.
My lord.
Page 16.
Yes.
Page 16.
That is in the
No, it is 12/6/1996 order.
Yes, sir. That is the annexure 1.
Yes.
He continued on 44 days basis. When he came for regulation, why his case was rejected for regulation, the lordship can find it from annexure 9, my lord. Page 29.
Well. Yes.
The lordsmith can find paragraph 5(6). That the I has not been regularized. He cannot,
Regarding non-existent post.
yes, ma'am. Why he cannot be regularized? That is the ground.
Look at the appointment order. She has been adjusted by some Jenna who was there in that post.
Regular post.
No, my lord. There is no such post at the time of his appointment. That is a non-existent.
Why is the post of Mr. Jenna is vacated?
Appointment order says in place of some Jenna, I Jenna or somebody.
And she has been transferred in the next page, my lord. Annexed to in page 2020. She has also been transferred to an existing post. The question of non-existence of the post is not arise.
The non-existent post was the initial post or the post where she joined in bottom back?
Well, what the rejection order said, that is a non-existent post.
This is not the gospel truth. Because
That I am showing my that rejection order.
We are seeing the original order.
Yes, my that in that original order, that is reflected that I adjusted against Aizena post. That is not clear whether Aizena was on transfer or on leave. That is not clear.
There is a post because it is full English. What Mr. Jena has vacated that post.
If Jena is on leave, that I have to take instruction on that part.
All right, and she was allowed to continue for all these years.
But yes, madam.
Subsequent council says that it's for 27 years. She has put this.
Yes, madam. That is 96 appointment. So he continued till 23. There is no dispute about it.
Yes.
Only that continuance is on order for that 44 days basis. And that our stand is that.
Mr. Kuntia, I think you are aware. This is most inappropriate labor practice by anyone.
Yes, ma'am. That's
just putting the mechanical brakes only to deprive someone legitimate expectation.
But your lordship, that we have framed a scheme that he does not fall within that scheme, my lord.
No, that we have seen. The clause, the condition number 1 squarely covers this case.
No, but
and that is already because she was not appointed. And these two clauses are contradictory to each other.
No, my lord. Why we have framed that scheme? Why we have put that 12 for 1993? That we have put a restriction on appointment of DLR NMR after 1994.
When this scheme was introduced?
On 15/5/1997.
All right. It is still in continuous.
Yes, that I am showing that next scheme that I have. You'll also see that next scheme that I have annexed that.
All right. What is the next scheme?
That you also can find it from page 6, my lord.
Page 6 of
that memorandum, like that my memorandum that 4th July 23.
All right. This one,
yes,
flag X. Flag X, yes.
And this is also that scheme that there that appointment date was fixed at 12 for 1993, and here we have made some modification that will confer them temporary status and subsequently against the vacancies we will adjust them for regularization.
But she should have initially appointed before 1993, and that the scheme is meant for daily laborers, my lord.
Then you are referring to 4/9/2012?
Yes, ma'am. That is. In for granted temporary observation of casual daily wages laborers engaged in different government establishments prior to 12 against regular group D vacancies. Here we have decided to confer them temporary status and subsequently they will be observed in a regular group D.
The same clauses you have repeated.
Yes, my same clauses, that only difference that we will first confer them temporary status and subsequently they will be regularized.
All right.
And next scheme that I have annexed at page 12, that is regarding regularization of contractual employees, that is not applicable to him.
All right. So this is the only ground because she was appointed before 1993, she cannot be considered under both the schemes.
Yes, but that is the ground. That Honorable Single Judge has held that since there is no scheme for them, they cannot claim regularization. Honorable Single Judge order.
Come to that order.
Madam. Page 38, madam. My lord, page 49, court's reasoning and order, my lord. Paragraph 20. Taking into account that observation in para 21, your lordship have directed me to produce those schemes.
All right. There is a 2018 Supreme Court decision. Because Justice Ms. Single Judge's observation is that Uma Devi will not apply. And there was two issues as not to apply Uma Devi because in the para 53 and para 57 Uma Devi's case.
Para 53.
Para 53 is a principal paragraph that says the 10 years will be the scheme and this will be the last and there will be no further opportunity. Right. They put a cap on the 10 years only from the date of the appointments of the concerned, not like the banning order or like.
Right.
There is an emphasis was the date of engagement. Then in 57 says that the appointments must be through a transparent method.
Right.
Others may be not regularized.
Right.
These are two ban was there. Regarding this lady, that you have no such objection raised in your.
Well, in that perhaps.
Just see in your counter affidavit, if you file the counter affidavit. Yeah. But from the judgment itself, it doesn't appear that you have raised such objection.
Counter is not with you that.
Whether they file the counter affidavit?
In writ appeal or
petition?
The writ petition they filed. And
that is why, because learned single judge also doesn't reflect anything about this objection.
Counter copy अच्छी है.
That's it.
Open this 2018 Justice MD Lokur on regularization. Oh, if you include this one is the open entry.
Stated on the counter at paragraph 9.
Oh, the judgment, we will find out the name of the parties.
Against the judgment of Uma Devi.
Oh, I think that one. No, no, basically. Sorry. This only one go there, that was the judgment.
Only the submission has been recorded at page 46 of it, but that in para 17, it has been noted that appointment petition is illegal and void. And no procedure have been followed to appoint to fill up the group D post. That has been reflected.
Name of the parties cannot be now.
Narendra Kumar Tiwari.
Narendra Kumar Tiwari, it is open, 2018.
No, that has been referred to in another judgment as this is complete.
There is Narendra Kumar Tiwari, 2018, no?
Volume 8, SCC 238.
Can you have the volume 8 SCC, 2021?
18. 2018, volume 8, SCC 238.
Bring it to 2018. This is Narendra Kumar Tiwari.
I have collected some judgments that state of corner, but not Narendra Kumar Tiwari's judgment is not with me.
That was the last judgment. And that was
that last judgment is 2022 that state of Gujarat versus RJ Pathan.
That is Justice Chandrachud's judgment.
Union of India versus Sandhla.
Justice Emerson's judgment.
Oh.
The 2019 Union of India versus Santlan. We just got a compilation. Hold on. The new. Ilmudevi, RJ Pathan, yes.
I have given that judgment of that Uma Devi and Satyaprakash versus state of Bihar and state of Dayalal, Union of India versus Ilmudevi and state of Gujarat, RJ Pathan, and S Plate 2010-13 SCC.
First of all, their judgment, RJ Pathan, the person who was working in a scheme. So this is not applied.
This is not applied. That we are also relying that Uma Devi that no transparent manner of selection was been done.
That is not taken. There is no reflection in the single judge's order.
Yes, in para 17, para 17 it has been.
Para 17 of the order?
Yes, para 17 of that judgment that they have noted the submission of ours.
There that he has shown no transparent method of.
Yes, my lord. Here, para 17, you also can find it from para 17, page 46.
That will say.
And in that rejection order, we have also taken that ground.
Paragraph 9.
You also can find it par.
All right. If that is there, because I was just usually glancing through it.
No, in paragraph 9 of your counter affidavit also you have stated.
I was asked whether that you have asserted the ground.
Paragraph 9 of your counter affidavit.
The counter is not with.
It's there.
And that paragraph.
It devotes the rule and not coming in the footing of
paragraph of the judgment.
Para 17, my lord, your lordship can page 46. Para 17.
Para 7 is something else in the judgment.
17.
17, my lord.
Okay.
Page 47, my lord. He further, but this is our stand. He further submitted the petition who is an outsider was initially appointed by the inspector on 27/6/90 with 1 day break between two spells of and continued as such on 23/4/2000. The police was re-engaged in government against Badamba from Mohan Subhadi High School, Badamba, against a non-sanctioned post without prior permission of higher authority and her continued in service beyond the yardstick.
This is your submission.
Yes, my lord. Prescribed by the government, thereby the appointment of is illegal. The appointment of the person and continuing the non-sanction is beyond the rules and
Yeah, does speak of the selection
and no
it's against a non-sanctioned post. That is the whole.
and no procedure have been followed to appoint to fill up the group D post. Page 48. And taking into account that honorable single just finding it that on para 20.
Regarding non-sanction post, my lord, it is not actually it is not non-sanction post. It is quite a sanction post. My lord, she was initially appointed in the boys' high school and subsequently transferred to the girls' high school.
Not a single just says it is a fresh appointment in that school.
Page 20. And that's after that, no 40 break was allowed also. She was allowed to continue. Page 20, Annex 2 matter.
He was entertained against the existing vacancy.
Yes.
Next order is clearly stated against the existing vacancy.
And retired from that post just last month.
He already retired.
Last month, when independence of the appeal, she was allowed to
It is
retire.
another difficult thing because if you are not in service,
Yes, my lord.
how to regularize your service?
That's why I had mentioned and your lordship was pleased to allow the time. Otherwise, the time was initial time for next hearing was during September, my lord. But your lordship allowed
We have preponed the case on considering that only. Book has closed. The book. I'm just showing you these two paragraphs. You go through these two paragraphs. There are 6 and 7 of the judgment. Let's quickly go through this. Use this.
Item 25. I got some difficulty after lunch. Can we post it to day after tomorrow or sometime next week?
Which one?
Is it PIL? Item number 25.
All of it will do it.
Your Lordship, Thursday or next week sometime. Monday or Tuesday. Your Lordship.
All it will just finding out a date, we'll fix it in the next week. Take a note on 25. This is completely a different interpretation. You just read. All the appointments are irregular so far the Umadabi is concerned. This is, they make a difference between the irregular and illegal appointments. Right here also I find this against a vacancy. This lady continued for more than 27 years of service.
Here admitted fact, he has continued, there is no dispute about it.
Right. And that you said that no vacancy was there, but clearly the Annex 2 shows that she was entertained against a vacancy.
That from the director's order, it is found that after verification, it was found that it was appointed against a non-exist. But that are the yes, I have seen that appointment. I have seen that.
Then how can you just go against the record?
That I have seen that the appointment order so that against an existing vacancy that I am not disputing with that, and I cannot dispute that. That record shows. But the director order says after verification of all the records, it is found that he was.
But the records is before us.
But how the inspector has said that is an existing vacancy and the director said there is no vacancy.
The director has not definitely consulted that order.
But they feel
take the instruction.
Yes, ma'am. That I will take in. How
it will that come tomorrow again?
Tomorrow, Monday, ma'am. Monday or fix. I'll take instruction on that one because.
List on Monday for continuation of hearing. Meanwhile, Mr. M.K. Kuntilan, additional government will take necessary instructions in respect of the observation made in Annex 9 and the record styled is office order dated 3/23/4/2021, Annex 2 to this memorandum of appeal. So you just go through that judgment. You have to go through the judgment of Narendra
Tiwari.
Narendra Tripura 2018 judgment. That is the only thing that can give you some resuscitation in your case.
But
Mr. Arun Naik for the
only difficulty may arise here, he has retired in the meantime.
That we will decide differently. Give a little succor to them. That is what. That a little succor is required because she will not get anything after 27 years of service.
I want that part I'll take in, so how that differs because that inspector.
That you take the instruction, other will decide.
Well,
I think that you have first done a wrong that you have not considered that case. Because 1993 doesn't makes a very good sense because someone is allowed despite the ban, and you are paying from the government exchequer, and she was getting paying the pay scale ad hoc employee, not a fixed pay. Why from the money was coming unless it was against a sanctioned post? There is a simple thing. It's to be understood very simply. This is an inexcusable exploitation. That you must understand that. You cannot do that. You terminate her, yes, all right. You realize there's a service for 27 years in an ad hoc post giving all the pay and allowances, and now she's completely without a farthing after retirement. Her physical existence is at stake. You have to consider that aspect also.
Right.
All right. Thank you, Mr. Kuntia, for this supporting so far. And I think there will be a positive instruction.
No, it's for 2 PM hearing. I don't 38
Call 34 then.
Item number 34.
I may be pardoned to mention item number 22. Actually, that was specifically mentioned to be listed yesterday, but on mention today it is in the list. But I think it may not reach today because of the some.
So there are 3 matters of fixed and 2. After that, we'll try.
Oh,
Item 38 supposed to be taken up first because already they have 34, 38. both.
It will take 5 minutes. Time.
38, sir. Just to recapitulate in 2 minutes.
Yes, yes.
The order of the tribunal is at page 23.
Yes.
And the operative portion at page 26, paragraph 5. The lordships have page 26.
Just 1 minute. Yes.
Paragraph 5, Your Lordship. It is accordingly ordered that the opposite party number 1 and 2 are directed to approve the appointment of the applicant with effect from the date of her joining, that is 17th August 93, and to release granting aid in favor of the applicant strictly in accordance with the granting aid order 1994, along with differential salary components within a period of 4 months from the date of communication of this order. My humble submission is this order does not state from which date the petitioner shall be allowed to take the benefit of arrears salary. Our humble submission is of the state is that the judgment of the Honorable Supreme Court in Tarsim Singh must be applied. Since the petitioner came before the tribunal in 2011, 3 years prior, with effect from 2008, he is entitled to arrears. That's my submission.
But this is a small point that was raised in this. Right now, just take your seat. It is very simple. Intention of the order is very clear. From the date they have mentioned, 17/8/1993, or to pay the arrears from that time.
Well, that is the approval of the appointment. It does not say.
No, just read it carefully. You are directed to approve the appointment of the applicant with effect from the date of her joining, i.e. such and such, and to release the granting aid in favor of the applicant strictly in accordance with the granting aid orders 1994. Maybe that order. No, it's communicating that. Don't complicate things in that way. Sorry. Heard Mr. A. Beral and counsel appearing for the appellant, as well as Mr. S. Jana, and counsel appearing for the respondent number 1. So there is no representation for the respondent number 2 when the matter is taken up. To challenge the order dated 12/2/2020, passed by the learned single judge in WPC number 2714/7 of 2017. The appellant has stated that in the order dated 12/2/2020, no date has been ascribed for granting the actual financial benefit. That is your plea. Stop. Mr. Arnav Dera, learned counsel, the learned additional standing counsel appearing for the appellant, has submitted that the actual financial benefit shall be restricted to 3 years, preceding the date of institution of the writ petition. Stop. To that proposition, Mr. Jena, learned counsel appearing for the respondent number 1, has raised strong objection and stated that a simple reading of the operative part of the judgment would make it abundantly clear that challenging that, I think.
You asking for a clarification or you challenging that?
Well, challenge. We had issued the order in past in compliance of the tribunal order. There we introduced the concept of Tarsam Singh.
All right. Just before that, no, just before that.
That is at page 30, Your Lord. That is the order.
Mr. Behra has placed his reliance on Tarsam Singh. The citation is you have
2008, my lord.
No, have you produced the judgment?
Yes, last occasion, my lord.
2008, 8 SCC 648.
Yes, giving the citation. Is not there. Have you given the copy of the Tarsam Singh? I don't think you have given.
I'm handing it over.
Yes.
Union of India and others, Tarsam Singh, 2008, 8 SCC 648. So in Tarsam Singh, the apex court has, from the doctrine of continuing wrongs, has given a new dimension in understanding the delay and laches. The denial of pay, which has been held in Tarsam Singh, gives rise on every day of fresh cause. But while observing this in respect of the otherwise stated matters, the apex court has observed that if the issue relates to the payment or refixation of pay or pension, relief may be granted in spite of the delay as it doesn't affect the rights of the third parties. But if the claim involved issues is relating to seniority or promotion, etc., affecting the others, delay would render the claim stale and doctrine of laches and limitation will be applied. Insofar as the consequential relief of recovery of areas for a past period is concerned, the principle relating to recurring and subsisting wrong will apply. As a consequence, High Courts will restrict the consequential relief relating to the areas normally to a period of 3 years prior to the date of filing of the writ petition. Mr. General Learned Counsel, appearing to the respondent number 1, has strongly contended that there cannot be any application of the Tarsam Singh as the orders dated 12/2/2020, Annexure 2 to the Memorandum of Appeal, is unambiguous, and as such, no clarification is required, or the challenge as raised on the basis of Tarsam Singh cannot be raised again, as the learned single judge has considered the principle of Tarsam Singh supra. Stop. In para 5, in the said judgment, it has been observed by the learned single judge as follows, quote, on the cumulative effort of the aforesaid facts and reasons, This court is of the considered view that there remains no justification on the part of the opposite parties in issuing the impugned order under Annexure 3 series in separation of the order passed by the Learned Education Tribunal and the order in FAO number 327 of 2014. Accordingly, the condition imposed in clause 3 under Annexure 3 series restricting the benefit for a period of 3 years is hereby set aside with directions to the authorities to extend the benefit as has been directed by the Learned Education Tribunal by order dated 2/11/2012 passed in GIA case number 489 of 2011. The entire exercise shall be completed within a period of 3 months from the date of communication of this order. Stop. The Education Tribunal what is the judgment of the Education Tribunal?
That is page 25 of the brief.
Also,
Relevant page 25, paragraph 4 and 5. The finding of the Law and Tribunal. And that has been confirmed in the appeal, FAO number 327.
the Education Tribunal, by the judgment dated 2/11/2012, delivered in GIA case number 489 of 2011, had observed as follows, paragraph 5 at page 26, but you take down. It is accordingly ordered that the OP numbers 1 and 2 are directed to approve the appointment of the applicant with effect from the date of her joining, i.e. 17/8/1993, and to release the grant in aid in favor of the applicant strictly in accordance with the grant in aid order 1994, along with the differential salary components. Within a period of 4 months from the date of communication of this order. This direction was challenged in the
page 29. The FAO was dismissed. State appeal has been dismissed. On 10/11/2014.
This direction was challenged in the FAO number 327 of 2014 by the appellant's hearing. But their plea is similar to the present, as raised in the present appeal, was dismissed by the order dated 10/11/2014. But there was no, but it said order is not on the basis of the merit of the plea, but the appeal was dismissed on the ground of limitation. Stuff. It is stated by Mr. General and Counsel that no challenge was taken forward by the appellant's hearing against the said direction of the Education Tribunal as aforementioned. But they issued a memorandum.
Page 30. They have implemented page 30 by fixing
They issued a memorandum
After filing of contempt.
memorandum on the face of the contempt proceeding On 15/7/2015, Annexure 3 series of the writ petition. So, by restricting the arrears pay to the 3 years preceding the judgment in terms of Darsim Singh Supra. The said order was challenged by the respondent number 1, and learned single judge has struck down the said order, holding that the respondent number was entitled to get the arrears from 2/11/2012, sorry, from the date when she was appointed, I think. She was appointed under the granting aid. Stop.
No, Honorable Single Judge only struck down para 3 of the approval order. That's not entire.
No, para 3 of the said order. Whereby the areas is restricted to 3 years preceding the date of institution of the GI case. Yes, there was no challenge against the order of the Education Tribunal. After their appeal was dismissed, after the appeal of the appellant was dismissed, it has to be inferred they have acceded to the judgment of the Education Tribunal. On reading of the passages quoted above, we do not have any confusion. The judgment intended that the arrears payment shall be made from the date of the appointment of the respondent number 1 under the granting aid. As such, the effective date for counting the arrears shall be 17/8/1993. The tribunal has categorically stated that the differential salary component shall be paid within a period of 4 months from the date of communication of the order. When in the orders, the differential salary has been mentioned, it does mean from the day 1 of the petitioner, the respondent number 1's joining under the granting scale, she will be entitled to the differential salary. As such, we dismiss this appeal being bereft of merit, holding that the Darsim Singh principle doesn't have any bearing in the present appeal. Stop. There should be no orders to cost. Before parting with the records, we direct the respondents to pay the appellants to pay the arrears in terms of our order within a period of 30 days from today. Petitioner, the respondent number 1 is also directed to furnish a copy of this order to the competent authority for compliance.
Well, may I pray for a small correction? Your Lordship stated that the arrears shall be with effect from 17th August 1993. The order 93. The order also reads and strictly in accordance with the granting aid order 1994.
Yes.
The granting aid order 1994 says that that eligibility shall in no case be a date prior to 1694.
Well, so that is why also kindly page 30 they will granted from 1694.
So it is from 1694.
So in accordance with the granting, just correcting, according to the granting rules, and there is no controversy in the bar that the effective date for applying the granting aid is
1694.
1694. It says the area shall be paid to the respondent number 1 from 1/6/1994. The entire amount on account of the area shall be paid within a period of 30 days from today.
1694 to till February 2008 because March 2008 he is getting. As per the approval. Only claim allowed 94, 1694
March
1694 to February 2008.
February 2008.
Okay. Item number 34. The WPC, the first one, that is the legal case, 4769 of 2020.
Hello, before my learned friend begins, I may point out to your lordship. Would your lordship see page 2?
Yeah, page 2 of the first
petition, my lord.
Okay.
My lordships are page 2.
Page 2 of the writ petition.
My lordship pleases.
Yes.
My lordship may see, words. The employer of the petitioner is opposite party number 3. And that is why they have made them a party, and rightly so, because they are their employees. And the notice says, words, that your lordships had issued notice.
Yes.
But they are yet to appear. Because it is going to be my argument, my lords. And I'm relying on Supreme Court judgments to that effect.
I will give the reply.
No,
the notice was issued.
Yes, but they have not appeared.
It was confirmed they have not appeared.
That appeared. I just wanted to bring this to your lordship's notice before the hearing starts, because I'm going to make submissions on this.
Some notice was issued. It is the preference of the party who will appear or not.
I only want to bring it to your lordship's notice.
Because issued they did not.
Yes, they did not come. Their employee did not come. That's the point.
Just before I begin, this matter was, of course, long back it was argued, but I need not want to repeat the argument which was advanced, but I just to recapture Lordship's memory, certain a date chart which I have already placed before Lordship, I want to just bring to Lordship's notice that date chart. Then I straight will take your Lordship to the law, because it is a question of challenging the violence of the rules. Lordship, kindly have a glance to that date of events in WPC 34769 of 2020.
All right.
Does you get it?
WPC?
The first one. The
769 of 20.
Yes, yes, sir. I've placed that date chart also to the lordships.
Yes, yes.
Just to, because my argument will be on the basis of the date of events with reference to the law. 83, 84, two pages more.
Yes.
The college of the petition that the medical college Kalar in the district of Jaspur was established and got concurrence. That was skip over. So for example, appointment is concerned, that is on 4/19, that is the serial number 2 in that college. Then we also come to serial number 3, 1694. Orissa Non-Government College, Junior College, Higher Secondary Schools, granting it order 94 came into force with effect from 1694. In pursuance to section 7C4 of the Orissa Education Act, regulating payment of granting aid to private educational institution. Then 95. So this 94 granting order came into force on 1694. 95, the proposal was submitted by the governing body to the director for release of the grant in terms of that 94 grant trade order, as the petitioner has fully satisfied the criteria under grant trade order 94, in section 74 of the Orissa Education Act. It is learned that though the proposal was submitted by the college in time, there was a delay in the level of the director to release the grant order in terms of 94 grant trade order. On 1896, in exercise of the power conferred in section 3B of the Orissa Education Act 1969, read paragraph 7.5 of the grant trade order 94. The petitioner institution, this is an important aspect, just mark it. Institution being a category 2 college, as per paragraph 4 of the GI order 94, was declared as an aided education institution with effect from 1694. Then 1996, in terms of the grant order 94, approval was accorded to some of the teaching and non-teaching staff of the institution for release of the direct payment of salary cost with effect from 1694. So some of the staff of the petitioner college, they got it on the basis of that proposal in terms of 94 grant trade order with effect from 1694.
Yes.
Then in 96, you expect time to ask this, that my argument will be based on this also. In 96, as and when the case of the petitioner was not considered for approval of appointment or release of grant order in terms of grant order 94, the petitioner approached this honorable court by filing a writ application using registration number 14057 of 96. Then, while that writ application was pending before the honorable court, you also had issued notice. While that matter was pending before the honorable court, on 5/2004, while the proposal was pending in terms of the grant order 94 before the appellate court number 1, and matter was pending before this honorable court, the state government will exercise the power purported under subsection 4 of section 7C, promulgated a new grant trade order, namely Orissa Non-Government College, Junior College of Higher Secondary School, grant order 2004, and by virtue of the said order, Rule 4 of 94 grant order was repealed, and the grant order already released under the grant order 94 was protected in repeal order. This Rule 4 is the subject matter of challenge in this writ application. In some other writ application, the entire the grant order 2004 has been challenged, but I confine my argument so far as this Rule 4 is concerned. Then 2008, the Orissa Non-Government College, Junior College and Higher Secondary School grant order 2000 came into force, and this 2004 grant order was repealed in 2008. Then 6/6/2009, another grant order, namely Orissa Aided College, Aided Junior College, Higher Secondary School grant order 2009 came into force. Then 23/2010, in terms of the Orissa Aided College, Junior College and Aided Higher Secondary School grant order 2009, the appointment of the petition was approved with effect from 1/2/2009. So that should have been, if 94, I could have got it from 1694, and my co-employees, they have got it from 1694 because of this repeat provision on section 4 of 2004 grant order. So they consider my case in 2009. Now next.
So now, one thing that at the time of taking other employees under the granting aid, your case was not considered.
My case was not, my case was pending before the director. I so that how my right is accrued, I so accepted my proposal by the governing body in terms of the 94 grant order was pending before the authority. Then serial number 12. That is also very important for me, so that I'm bringing to also notice. The application which was filed in 1996, before by the present petition, was transferred to the Orissa State Education Tribunal by this honorable court, by which was remembered as 38 of 2014, the enactment of section 24B of the Orissa Education Act, conferring power upon the State Education Tribunal for adjudication of all matter relating to grant. I expect kindly, of course, my learned friends should have noted here, this section 24B was incorporated to the statute in the year 1998. No, I'll bring to your notice.
Yes.
Then on 1/2018, Lawrence Tribunal by order dated 1/2018 allowed the application preferred by the present petitioner by setting aside the order dated 23/2010 and further directed the opposite party number 1 and 2 to approve the appointment of the petitioner under the granting order 94 and release the granting rate in terms of that 94 granting order. That is Annexure 7. Tribunal allowed the application. On 2020, again that order between 1 to 2018, the state government preferred to review the petition, but the petition was dismissed before the tribunal. Then serial number 15, 2020. The state government preferred a statutory appeal under section 24C of the Orissa Education Act. Wherein account numbers also, after a delay of more than 2 years, which is pending, the only plea of the state government, you also kindly mark this, the only plea taken by the state government in the aforesaid appeal is because Rule 4 of 2004 granting order, the granting rate cannot be dispersed as per the granting order 1994. The state heavily relied upon the judgment passed in case of Anup Kumar Senapati, in which the effect of repeal was discussed. The judgment in Anup Kumar Senapati was a case where if Rule 4.1 has come into force because of the repeal provision, whether the 94 granting order is still in existence or not, that is the judgment that they are relying upon. Now you also kindly come to the statute. Because I am concerned of the fact that it is a clear case of, it is a virus, challenging virus. I must confine my argument so far the legal question is concerned. Well, I am holding your Lordship's book, I think the same book. Well, certain provision I will show your Lordship's.
Why you have challenged this Rule 4 of 2004 GI order? Yes.
Because Rule 4V, they have repealed 94 grant rate order. But they have said, I'll show that. Let me come one after the other.
Which ground you have challenged?
I have challenged the repeal provision on the ground. That's why I have prepared also. I have given to us the point of law. I have given to us. Point of the earlier I have given to us. I'm just. I think you also marked it also somewhere.
Yes.
I have subsequently developed some other points, but still these points are also in the initial it was there. That whether pursuant to section 7C, subsection 4 of the Orissa Education Act, read with the provisions provided in the Orissa Non-Government College, Junior College, Higher Secondary School, granted order 94, the right which has already been accrued in terms of the aforesaid statute in favor of the petitioner, can the same be annulled by repealing the provision of the Rule 4 of the Orissa Non-Government College, Junior College and Higher Secondary School, granted 2004. Then 2. Whether there is a reasonable nexus with the object sought to be achieved by repealing the 94 granted order. 3. Where by virtue of the repealing the provision of 94 granted order, an artificial classification has been made out of the same class of the employees, which will lead to gross discrimination as envisaged and guaranteed under Article 14 and 16 of the Constitution. 4. Whether the judgment rendered in the case of State of Orissa versus Anup Kumar Senapati and others reported in 2019 SCC SWAT can be applied to the present facts and circumstances of the case, where the virus of Rule 4 of the granted 2004 is the only subject matter of challenge.
In Anup Kumar Senapati, whether this virus of
No.
challenge.
Rather, on the basis of the Rule 4, the single judge of this Honorable Court held that the effect of the repeal provision is that means from the date on 1694 when the granted order 94 came into force, that is no longer in existence with effect from the date the granted order 94 came into force. And that was upheld by the Supreme Court. So therefore, under these circumstances, we have no alternative except to challenge this violation of Rule 4. Because we have succeeded before the tribunal. Now, only now they have taken in the appeal. In fact, the appeal, the order was passed, expired order was passed on the basis of Anup Senapati case. On filing an application, the order will be recalled. But the only ground is Anup Senapati, only ground is repeal, nothing else. Now you are speaking. Whether the right of the petitioner prior to repeal of 94 granted order, who have approached the competent court of law, to respect like this, who have approached the competent court of law, and their right has been declared in terms of 94 granted order, can the judgment of the tribunal or competent court be annulled by virtue of the implement Rule 4 of granted order 2004. 6. Whether if the teaching and non-teaching staff were covered in the Orissa Education Institution Appointment of Lecture Validation Act 1998 and held to be entitled for approval of their appointment in terms of granted order 94, even after the same granted order was been repealed, can the petitioner who stands on a better footing can be treated as a separate class from the class of employees whose service have been validated under the Validation Act. Then seven, whether even after repeal of the 94 grant order by virtue of Rule 4 of the Act of 2004, the benefit of 94 grant order has been extended to person similarly situated as that of the present petitioner, even after the pronouncement of repealing order 2004 came into force. I respect, I will come to the statute so that I can address your worship on these points. Your worship, kindly come to Orissa Education Act. Your worship, kindly come to so far as what is the definition of aided educational institution, section 2B. Your worship, come to page 115 of your worship book. The only provision I am going to cite to worship, which is necessary for the purpose of adjudication, no other provision I will cite. You need some theory, but I will not address worship, I will not bother your worship to other. Worship, kindly come to section 2B. Sorry, section 3B. Sorry, I'm sorry. 3B. Aided educational institution means, let's get it. 3B. Aided educational institution means private educational institution.
1 minute.
Sorry.
Is this the same thing, education code?
No. Orissa Education Code, what happened here, prior to the Orissa Education Act came into force in 1969.
I got it.
Yes. No. Aided 3B. I think same group also I am holding 115. 115.
3B. Yes.
115. Aided educational institution means,
Yes.
Aided educational institution means private educational institution which is eligible to, yes, market, which is eligible to and receiving grantee aid from the state government and includes an educational institution which has been notified by the state government to receive grant. Now, what I have understood, three requirements. One is must be eligible. Second is receiving the grantee aid from the state government. Third is includes an educational institution which has been notified by the state government to receive grant. These are the three criteria so that you have to bring within the definition of aided education institution.
Whether the status of the respondent number 3 has been questioned, that they are not aided educational institutions.
They themselves have declared this institution to be an aided.
There is no controversy.
There is no controversy. Why I am saying so, I take it to that provision, how it is connected to this. That is why then we also can come to section 7C, on the basis of which the rule has been framed. That is at page 137.
Yes.
137. The state government shall, within the grantee aid, also market is grantee aid. Concept is grantee aid. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for giving as grantee aid to private educational institutions in the state. Perfect. Then come to 3. Please no order is not relevant for a purpose. 3. Save as otherwise provided. No private educational institution which has not been recognized by the state government under the Act shall be entitled to receive it. There is no dispute also over this. Then kindly come to 4. Notwithstanding anything contained in any law, rule, executive order, or any judgment, decree or order any court, no grantee shall be paid, and no payment towards salary cost or any other expenses shall be made to any private educational institution or any post or to any person employed in such institution. To educational institution, post to any post of that institution and to any person employed in that institution. After the commencement of the Orissa Education Amendment Act 1994, except in accordance with an order or rule made under this Act, granting aid where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. So pause for a moment below. Prior to this section 7C1 and 4, this was incorporated by way of amendment by Orissa Act 14 of 93. in fact, was given effective in 94. And prior to this 7C came to force, the grant was being released.
No, we said 14 of 1993 is a purely an amendment act.
A purely an amendment act, yes. Sir, this is a substantive act, and by this provision it was incorporated how the grant has to be released.
So better we forget this Orissa Act number 14 of 1993 because it is already incorporated in the
yes, sir. This is incorporated. Yes, so this is a capsule correct. Orissa Education Amendment Act 94.
Yes.
Now this has been incorporated by Orissa Education Amendment Act 1994.
Yes.
So now, before this 94 year, the granting was being released by virtue of executive instructions. That's right from 1983, the executive instruction was issued. They were giving on the direct payment scheme by virtue of the executive instruction. For the first time in 1994, For the first time in 1994, for the first time in 1994, this was incorporated in the statute, in the act itself, that any grantee will be paid, that will be paid pursuant to an order or rule to be paid pursuant to the Orissa Education Act. So that is why Section 7C4 said, henceforward, after this Amendment Act 94 came into force, the granting aid to the post, granting aid to the educational institution, granting aid to the employee has to be released in terms of the provision to be made under pursuant to Section 7C4. Am I clear? Now let's kindly come to the working power that is rule Section 27. That is at page 158.
Yes.
No, we also come to page 159, 24B, because I am also come to, before coming to rule the power, also come to the provision 24B. That is the adjudicating authority. That is at page 159. Let's look at it.
Yes.
Adjudication, I am placing 24B. Adjudication by the tribunal. Tribunal has been constituted pursuant to Section 24A. We are concerned with 24B. This 24B was incorporated by, sorry,
yes,
by Orissa Act 5 of 98. Can you see?
Yes.
This 24B, adjudication by the tribunal. The tribunal shall have jurisdiction, power and authority to adjudicate all dispute and differences between the managing committee or, as the case may be, the governing body of any private educational institution and any teacher or employee of such institution or the state government or any officer or authority of the state government relating to or connected with the eligibility, entitlement, payment or non-payment of grantee. So all matter relating to eligibility, entitlement, payment and non-payment of grantee, that power was conferred on the tribunal, a specific tribunal, which is presided by a senior district judge, in terms of Section 24B, which was incorporated by the statute in the year 1998. That whatever the dispute relating to grantee, under that grantee order to be framed pursuant to Section 7C4, that will be adjudicated here. Then, any person adjudicated, any person agreed by an order pertaining to any matter within the jurisdiction of the tribunal, no an application to tribunal for the reversal of the grievance. On receipt of the entry, on receipt of the application of the subsection 2, tribunal shall, if satisfied of such inquiry as deemed necessary, that the application is fit case of adjudication, by it admit such application. But where the tribunal is not so satisfied, it may somebody reject the application after according
reading this.
This is a substantive act. Act confers a power on the tribunal to adjudicate all dispute. So far as present petition is concerned, he raised that dispute before this honorable court in 1996. While the 98
by operation that was transferred to that.
That by operation that was transferred to the tribunal. Now the question,
nobody is questioning that.
Sir, now the question is, while the matter was pending for the tribunal passed some orders, or while the matter was pending for adjudication, then now they have brought it 2004 grantee order by provision under 94 grantee order. Now the question for consideration for RCP is, if the statute, the substantive provision is the Orissa Education Act, Substantive provision is 7C. Substantive provision is 7614, on the basis of which 94 granted order has been framed. I'll bring to also that 94. The 94 granted order have satisfied all requirement. The right is accrued. You have to remember that you wanted to know that what is listed on the accrued right. Here is a case where both listed and accrued right and come up with a judgment which is directly applicable to this case. So now the question is, the right which is accrued or listed because of his right for adjudication. His right for adjudication, I don't say the right to get such benefit. My right of adjudication pending for the tribunal, can such right be taken away by a subsequent legislation but by the state pursuant to section 7C4? First point.
They also explain how this subsequent amendment takes away your right.
Sir, kindly come to sir. That is therefore I'm taking to us one by one.
Yes.
So, just let me finish this Orissa Education Act provision, then I'll take your answer to that. You also come to section 27, because that rule making power. Rule making power. That is at page 165.
Yes.
165. Also see, power to make the rule. The state government may, after previous publication, make rule for carrying out all or any of the provisions of the act.
I think you'd like to read subsection 4.
Yes. No. Here, yes. 4. Also true. Why I'm saying so, this has to be placed in the Legislative Assembly. If a rule is to be made in terms of Rule 27, it has to be placed before the Legislative Assembly. That's a good to think.
Yes.
In respect to 27, we say in respect of all that is expressly required or allowed by this act to be prescribed, all rules made under this section shall, as soon as may be after their bed, be read before the state legislative for a total period of service. Also, I did not has to be placed before the Orissa State Legislative Assembly. And until rules are made in this section, the rule contained the Orissa Education, we are not concerned with. The Orissa Education Code is no more in force after the act came into force. There is no dispute about this. But I am concerned with 2 and 3.
Always.
Now you will also kindly come to page 545 to 94 granted order which was framed. Which must be kindly come to page 5. That is 545. 545. This is what Orissa, let's get it.
Yes.
Orissa Non-Government College of Junior College and Higher Secondary Schools Granting Order 1994. Where also see non-government colleges mean degree college, junior college means plus 2 college, and higher secondary school also plus 2 in 94. We also see in exercise of the power conferred by subsection 4 of section 7C of the Orissa Education Act, the state government do hereby make the following order to remove payment of grantee rate. What's mark this grantee rate? How far my argument you also will accept, but that is also an argument from my side. Section 7C says grantee rate. And 7C4 says that pursuant to 7C4 they make a rule and order grantee rate. Now, we also see in exercise of the power controlled by subsection 4 of section 7C of the Orissa Education Act. The state government do hereby make the following order to regulate payment of grantee rate to private educational institution or for any post or to any person in such institution, being non-government college, junior college, higher secondary school, as specified herein. So now they have made this provision 94 grantee rate order so as to consider the question of grantee rate. At this stage, you also kindly come to just I will take your answer to Rule 9. Order number Rule 9. Because we are the persons. The persons. That is the provision Rule 5 that is in respect of institution. Rule 9 deals with the persons. Just as for 1 minute only, Rule 9, the teaching and non-teaching post in non-government education institution coming under category 1, we are coming under category 2, we also come to Rule 9 to Roman 2. Roman 2, sorry. Rule 9, clause 9 to capital B, Roman 2.
Has been amended the period prior to the commencement of the Amendment Act.
Yes, sir. Yes. The post in an government educational institution coming under category 2 Admittedly, were category 2 was no dispute. The post was admissible as per the workload and aspect prescribed in order has been in the prior to the commencement of the Amendment Act, and it has completed qualifying period of 5 years or more, which you have done. In our case, well, we have complied with, there is no dispute over that. Now you also kindly come to Rule 15, Clause 15. Page 558.
Yes.
The government of the non-government educational institution notified or which applied for notification. So just carry in mind that is the notification of the grantee. In our case, it has been applied and notified also. But it was applied. The government of the non-government government.
Whether it is an applied and notified or only applied?
No, it was applied, then subsequently it was notified. And some staff of the colleges, they are also released the grantee on 94.
What is that notification?
That is there. We also come to the lecture.
Annexure 1.
Annexure 1.
All right.
Annexure 1. That was on 8th March 1996. If you also will come to page 18, running page. Well, I'm driving to your worship and making my submission only for the purpose to take your worship, whether my case covered under the right accrued or vested by virtue of this act and rules.
All right.
Yes. So look to that page 18 annexure 1. In pursuance of the power conferred under section 3B of the Orissa Education Act, read with paragraph 7.5 to Orissa Non-Government College, Junior College, Higher Secondary School, Granted 94. The state government do hereby notify the following 14 non-government education institution as aided education institution with effect from 1st June 94. That's a market.
Yes.
Subject to the provisions of paragraph 20. Paragraph 20, that is the usual thing, sir. Paragraph 9 is serial number 9. College, Kalam in the district of Jaspur. This has notified. And under the 94 grantee rate order, who eligible to receive the grantee rate with effect from 1st June 1994. That's all one way. And by which of these, people also will look to the next order where they have released the grantee rate in respect of some staffs. That is, I have given in my big chart. That is on, this notification was made on 8th March 96, and they have released this 1996, they have released that. This is 8th March, that is 19th March. That is at annexure 4, page 39 of the application. That is serial number 6. So now, you also again come to the statute, that 94 grantee order. 15 and 16 I'm taking heed of these provisions, which has been interpreted by this Honorable Court by division judgment, on the basis of which, after the repealing provision was made, they have extended the benefit to 234 colleges, degree colleges, and 39 colleges. Incidentally, I was also counsel there, and that has been upheld by the Supreme Court, and they have extended the benefit of grantee rate under grantee rate of 94 in the year 2011 with effect from 1694. Can we come to clause 15? The governing body of a non-government educational institution notified or which applies for notification as an aided educational institution shall furnish proposal in regard to the person or persons who is are eligible to receive grantee rate. That's a mark. Eligible to receive grantee rate against approved post or post eligible to be approved from time to time, indicating the full justification for the proposal. The governing body shall internally furnish information on following. This is an information the governing body is a duty passed upon the governing body under the statute, submit a proposal in respect for notification of aided colleges and for approval and for release of material in respect of the post and in respect of the person holding such post. And information, these are the information. Then what is the duty of the authority, director? Can we come to 16? The director is the prescribed authority. 16. On receipt of a proposal, I think I also yes. On receipt of a proposal from the governing body under para 15, the director shall examine each case, and if he is satisfied that the persons proposed by the governing body is eligible to receive grantee against an approved post, he shall make an order to that effect, where the director is satisfied that a person proposed by the governing body is not eligible to receive grantee, whose decision shall be communicated to the governing body. The two things below. On receipt of the proposal submitted by the governing body, he shall examine the case. Yes. And if satisfied the person proposed by the governing body is eligible to receive grantee against an approved post, he shall make an order to that effect.
Whether the governing body has proposed your name?
Yes, sir. Can we come to sir paragraph? Specifically, I have said in paragraph that is also admitted. Nobody denied that. Para 7 also look to that. They have not denied this. So I have said like this. Para 7, internal page 5. After the grantee order 94 came into force, the then governing body submitted necessary proposal in the prescribed form in terms of the grantee order 94 for release of the grantee in favor of different eligible employees, including the petitioner, as required under paragraph 7 of the grantee order 94, and accordingly the steps on
paragraph 5 of the writ petition.
Para 7. Para 7. Internal page 5 of the writ application, para 7.
5 is the page number.
Yes, sorry. I'm reading it again.
No, it's all right.
Sir.
I have heard you.
Sir. So, therefore, the proposal has been submitted by the governing body in terms of the grantee of 1994 to give release the grantee in favor of the petitioner. That is no denial. Now, the question is, and I have also said that so far the para 16 is concerned, the director has not communicated any order injecting the application to the governing body. That is also the case of the petitioners. And reading together 15 and 16, I will not repeat it again. The governing body required to submit proposal, which has been done in the present case, and so far the requirement of 94 grantee order, admitting the petitioner satisfied all the requirement. 15, 16 says they have to consider it. If they reject it, they will have to communicate. No communication has been made. Now, I expect I will come to
yes.
Page 443. The provision that order 2004. Yes. That is 468. Sorry, I'm 468. 468 of the book. This is that 2004 grantee order. We also see the concept of grantee is in the statute itself, in the act itself, grantee. And accordingly, 94 grantee was also made in terms of section 7C4. They have not utilized section 27, which is a rule-making power. Anyway, that's all right. But that is because the statute provides 7C1, grantee has to be released, and that must be in terms of 7C4. The order to be made in terms of 7C4. Now, for the first time, this 2004 grantee order was issued, which according to the repeal provision has been challenged of this 2004 and reading that. In exercise of the power conferred by subsection 4 of section 7C of the Orissa Education Act, the state government do hereby make the following order to regulate the payment of grantee to private educational institutions, being non-government colleges, junior colleges, higher secondary schools. In para 3, admissibility of the grantee. Every private educational institution, being a non-government college, junior college, or higher secondary school, which has become eligible, that's a market, which has become eligible by 1st June 1994, to be notified as an aided educational institution pursuant to the grantee order 94 shall be notified by the government as required under section and under clause B of section 3 of the Act, and the institution so notified shall be entitled to receive the grantee by a block grant. That's a kind of market.
Yes.
They incorporated block grant for the first time, that too, an institution which has satisfied the requirement and is entitled to be eligible to get the grantee with effect from 1694. That is, now they say, you are entitled to receive gratuity from 1694, but by your block grant, depending the manner provided in subparagraph 2. I am reading it again here because it has the meaning will also find how can they encroach upon the provision of the Act itself. Every private educational institution, being a non-government college, junior college, higher secondary school, which had become eligible by 1st June 1994 to be notified as an educational institution pursuant to Grant Order 94, shall be notified by the government as required under clause B of section 3 of the Act, and the institution so notified shall be entitled to receive gratuity for by the block grant. And how that block grant will be given, that is provided in subclause 2. Let's come to subclause 2.
Mr. Rautri, that one thing that your name was never consented by the director.
Not considered.
Not considered. So
I can say that not considered.
Then you providing the granted of this stock at that point of time.
Right, sir.
And still it is continuing in that.
Right, sir. That my right is only for adjudication, and that adjudication has been made by the tribunal.
How are you continuing in this institution?
By receiving block grant? By receiving block grant?
So
I was allowed the job.
Respondent number 3 is providing you the grant in aid.
Yes, sir. Only with block grant in 2009.
Unauthorized leads.
Yes, sir. Sir. They have accepted. But they have accepted my appointment. They have accepted my eligibility on the 94 grant order. They have accepted that the proposal has been submitted.
The appointment must come from the government through the director.
Sir?
Approval should come from the director.
Yes, sir. That was the 94 grant order. While the consideration for grant under the 94 grant order, they are required to approve the appointment in terms of 94 grant order, provided the persons are satisfied with
what are the consequence if they do not grant or they do not approve it? Asking the question,
sir.
If they do not approve the appointment,
right, sir.
The person is not entitled to get the salary under the grant in aid?
No.
How this block grant can be utilized for making payment to that person?
They have done it.
I think that is why the Advocate General at the very beginning pointed out, finger at the respondent number 3.
Yes.
This is
that question the right time. No, I'm coming to that also. Right time, because I was trying to place directly the provision. But while I was going through this provision on the 2004 grant order, I found that yes, sir, I accepted that my appointment is valid. You accepted my educational institution should be eligible to receive grant for 94. And now you said that grant is a direct block grant. What is the interpretation of 3.1? 3.1 of 2004 grant order, if I have correctly understood, that I have become eligible, my institution has become eligible, my post has become eligible from 1694 in terms of the grant order 94. The 1694 concept, they have brought it under 94 grant order. And that grant order has been made for the purpose of release of grant, not grant. And so far the Education Act is concerned, section 7 has not been amended. And why the right of adjudication of the section 24B has not been amended. Whether it had to be amended, but it is considered that the position is different. 24B is there. And section 7C 94 is there. Now they have brought it 2004. Now also again we come to that 2004 subclass 2. The block grant,
yes,
2, page 469. The block grant payable to the private educational institution under subparagraph 1 shall be fixed a sum of grantee rate, which shall be determined by taking into account the salary and allowances as on the first day of January 2004 of the teaching and non-teaching employees of the educational institution, which have become eligible to receive grantee rate by first day of June 94, in accordance with the grant order 94. But the determination of the quantum of such block grant shall within the limit of economic capacity of the government, as mentioned in subparagraph 1 of section 7C of that, and shall have no linkage with the salary and allowances payable to any such employees by the governing body from time to time. The proper amendment. What they have done it? They have done it that though you are entitled from 94, 1694 in terms of grant order 1994, but the block grant You are only to get the block grant from 1st June 2004. That thing that depends upon the economic capacity of the state government. They will fix up the quantum of the block grant.
11,000.
Quantum of the block grant. Maybe 10,000, 9,000, that doesn't matter, 11,000. Now you also kindly come to the repeal provisions. Repeal and surrender. The Orissa, let's get it, repeal, which is the subject matter of challenge, the Orissa non-government colleges, junior colleges and higher secondary schools, granting order 94 is hereby repealed. Save for the purpose mentioned in subparagraph 1 of para 3. Let's say kindly pass for a moment. Still, I am confused. Myself is confused. If you repeal the provision, but you made a civil clause, particular civil clause, save for the purpose mentioned in subparagraph 1 of paragraph 3. That means with effect from 1694, I have become eligible. 1694, they are eligible. But the receipt of the grant is by block grant. That will be determined under rule sub-rule 2. That means that block grant will be determined under sub-rule 2. And we also at this juncture also need to quote 2. How they have made the discrimination. Notwithstanding the repeal of subparagraph 1, the private educational institution which are in receipt of any grant from the government under the order so repealed, immediately report that the date of commencement of the order shall continue to receive such grant as if grant 94 has not been repealed. What they have done, suppose this came into force on 5th February 2004. On 4th February 2004, if somebody has received the granted 94 granted order, exactly which happened in my case, the other co-staffs, even those who are junior to me, they have received the granted just before this repeal provision was made. They continue to receive the granted 94, whereas because of this repeal provision of 2004, 4.1, we are deprived of getting the granted from 94, and our block grant is to be given by calculating their own way in 2004 itself. But they have given it in 2009. This is what they have done.
But now, you have not raised the challenge against the...
Yes,
all the junior these teachers?
Yes.
Yes.
96.
No, there is no challenge. So party before this.
So far, I am not challenging the so far the seniority of junior. I am only saying
no. The moment you say that they are junior, they are giving this thing.
For the purpose of
you have to your plea should be shaped as that you are not challenging any right to the junior. Yes.
Consider.
Yes.
Consider. I challenge.
Court will only just.
Yes, sir. So my right.
Whether did you have any right at that point of time?
Right, sir.
According to the rules.
Right.
If we do not find there was any right, you are
yes, sir. Yes,
no case.
Yes, sir. So now the whole question for consideration is, I may not misunderstood. So for the juniors of that, that is not my case. My case is...
No, you are making a comparison. When my juniors...
No, not that. Discrimination.
You cannot keep discrimination at this stage.
Yes, discrimination is this way. The persons appointed in the same institution. Yes. Just I'm putting it this way. That institution is notified in terms of the Article 94.
Yes. And nobody is questioning them and there is no controversy.
No controversy. Absolutely no controversy. That. So therefore, institutions. Now the question is whether I will deprive of the benefit in terms of that notification that it become an educational institution to receive the grant with effect on us.
Is it automatic?
Yes.
Is it automatic?
It is not. No, it is not. It is not.
Because even at the time of taking over also, all the teachers or the other non-teaching employees, their appointment should be approved.
Yes, sir. So that is,
and the salaries and appointment in the indicators, how much of the block grant you will get. That has been provided expressly.
So for the 2004 granted order,
exactly.
That is my appointment is approved, that is you are entitled to block grant.
Exactly.
Block grant. Now the entire term before SC2 is, I'm just putting it this way. Section first by my first point.
Also, you argue on other aspects also that if you are not having the support of law, so for your appointment or engagement is concerned, what is your right? You know, what is your quasi right to claim something before this court?
Sir, so far as the my right, there is no dispute with regard to my appointment.
But we understand.
Sir, there is no dispute.
Appointment under the respondent number 3 may not be questioned.
Sure.
But the question is whether you are appointed under the granting aid or not. That is the question, and that is the reason.
That is exact point, sir. That is an exact point. If pursuant to section 7C4, you have made the provision of 94 grant order, and I satisfy the requirement in terms of 94 grant order.
I satisfy all the requirements to be the judge of international court.
Well, that's not a question, sir. So,
unless you channelize through the process.
Sir, channelize, but not case.
Channelize, but they have not approved it.
Sir, now the question is, the adjudicating authority conferred on the tribunal. So, I raised the question before the tribunal. Now, tribunal adjudicated and decided my. Now, the question is, my right of adjudication before the tribunal can be taken by 2004 gratuity order.
That is a separate issue.
That issue when I am raising before SFCs. If pursuant to the Act, certain right is accrued in my favor provided your worship will accept, and that right I have the right to raise before the appropriate authority, that is the tribunal under the statute itself.
And also whether the tribunal was aware of these changing rules while deciding the matter.
So that time, the judge, at that time, the question of the Sahib Senate did not come into force, sir. No. So the question is, sir, whether the right before granted or entitled to get or not, that was the question. But by the time the judgment was pronounced by the tribunal, this 2004 granted was already come into force. The whole question is, sir, I am not saying, am I not making a submission?
That is very clear that if in 1994 you had any right to be considered, and that was not considered, definitely that can be decided on the basis of your status on that particular date of your appointment, particularly that 1/4/1996.
1/6/94.
If that on that day he has any right, that should be treated as a vested right. There is no.
That's it.
But whether that right was there or not.
Sir, that right because of this, the Act itself, and I'm putting the further.
Because the right to consider cannot give you the vested right.
Sir, right to consider is one part, sir. The question is my right of adjudication to be considered in terms of 94.
So you limit your relief now to that extent that I had a right to be considered and that was not considered.
Because of the slipping provisions.
Yes.
And my right to be adjudicated in 24B, that is still there. We want now encroach upon the right which is conferred on the basis of the Act itself, on the basis of the statute itself, by making a rule that is order 2004, where you have taken the right to be considered.
No, that is a separate issue because the subsection 2 of section 4, this repeal provision, it clearly saves the provisions of the earlier order.
Yes, that is only percentage of any receipt.
No, that's there.
But those persons are to be considered by them. That is
there is a subsilent. There is nothing. Provision is not there. No provision is expressly provided. Those who are not considered, they will not.
No, they don't say that. They say that those are received that is there. They are protected. But few one and this fourth one,
yes.
Few one said that they are entitled from 94. You have to look again. And more important is my institution has been declared to be an education.
There is no dispute about this.
There is no dispute about this. Now the whole question is whether my right to be considered on 94 can be encroached upon by this order 2004. And the other point which I raised before, also possibly I was not clear, the section 7C 1 or 4, yes. That relates to granting. That's the related to granting. So, but this concept of block grant was never there in 2004. But in 2004, by surrender legislation, that incorporated block grant. So now, whether and if you actually go through the 2095 grant details, that is the exhaustive one. Very exhaustive one. How it will be considered, the best qualified, 5 years must have been completed, everything is there. And there is no deal. So far as that part is concerned, there cannot be any dispute except they say that we are not considered.
Still you are in the service.
Yes, sir. We are getting the block grant. We are getting the block grant. You have one judgment also.
You are not getting the block grant. Institution is getting the block grant.
No, instead I am getting the block grant, sir. That's one is institution, one is post, one is person.
Always that will examine.
Sir.
You are getting the block grant or not.
Sure, so far as we are, there is no dispute that we are receiving the block grant. We are getting the block grant.
Because my understanding of the block grant is that it is this aggregate of the requirement of the
we used to make a calculation on the basis of the.
That is the rule provides.
That's right.
These indices are to be gathered together to find what will be the block grant. Means there is no individual block grant.
What they have done,
So that is
yes, in 2008. In 2008, also subsequently, but we see what we agreed in 2009, they made another order. And on that 2009 order, they are giving a block grant to the petitioners. In 2009.
All right. If you are
cases, one judgment I will cite at this juncture.
I think you are concluding now.
No, I'll take it. So, I'm sure you are. Well, what has happened here, so far the discrimination part is concerned, but they, after the 2004 grant order came to force, which is now subject matter of challenge, about 139 degree colleges and 38 junior colleges. They are not considered 94 granted order on the ground that there is a financial crunch. Those, all the colleges, they approach this honorable court in writ applications. And in fact, while these writ applications are pending, this repeal provision was made. But it was a matter of 2002. But the judgment which was pronounced by this court in those cases, that 94 granted order, once the section 7C1 says that you have to, within the economic capacity, you have to make the budgeting provisions. On the plea of budgeting provisions, you can't say, you can't deny the right of the person to get the benefit of 94. And that judgment was challenged before the Supreme Court. All the cases. And those judgment, the judgment of this court was upheld by the Supreme Court, and they released the grantee under the grantee of 94 with effect from 1694 in the year 2011 in respect of those 130 colleges, degree colleges, and 39 plus 2 colleges. If your case is now, because it has been repealed, the 94 grantee order remain in existence, but you yourself have extended the benefit to same class of employees, same class of institutions, and also both degree and junior colleges.
What is the decision?
That decision is given to us. That population has served as a state of Orissa. The judgment Supreme Court also given. That was report. That is delivered on. Supreme Court order I will post in that case at page 56. At page 56. Judgment proposals of this court are giving to the ultimate state of the Supreme Court that has been upheld. We have carefully gone through the improved judgment passed by the division bench.
Is 56 of the compilation?
No. It's of the brief. The judgment of the proposals by the High Court, by the Honorable Court, that has been appealed by the Supreme Court in 2010, on 18th August 2010. And their entire case before the Supreme Court was, because of the repeal, they are not entitled to get the grant under 94. That was the entire case. I've given the copy of the assembly petition also.
That's all.
Kindly see page 56. We have hired a counsel for the parties.
There is nothing. There is no discussion even.
No discussion, but the judgment of the High Court is very well judgment.
They were directed to implement that judgment.
Directed to implement the judgment.
Okay.
And you actually kindly see the judgment of proposals of this court. That is, if you actually look to entire 90, the compilation that starts from page 1 and page 12, you actually kindly see the judgment of proposals. Para 13, 14, and 15. Para 15 also see, because the worship of
paras 14, 15?
14 and 15.
Only.
Yes, para 13 also they have referred to that 13 provision of the 94th Grantment Order. I may not kill your worship's time. Para 15.
All right, that is your case.
My case, I have to raise some judgments.
Please.
Yes.
I'll just come from the other court.
Para 40, also turn to para 40. Yes. In Chandigarh administration and others versus Rajendra Bhali, the Supreme Court has rejected the contents of Chandigarh Swansu that was difficult to bear the fact.
Is it in your compilation?
Yes, that starts with page 1, the proposal judgment. It will also come to page 9. Para 12. I think let's get it. In para 12, I'm pressing. In subsection 4 of section 7C of the Orissa Education Act, however, it is clearly stated that the granting were admissible under the rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. We have perused the provisions of the Granted Order 1994, and we do not find therein any mention as to the date from which the granted rate will be payable. Clause 16 of the Granted Order 94, on which great reliance was placed by Mr. Swami in support of the submission, that granted rate will become payable as soon as the eligibility to granted rate decided by the director is quoted hereunder. Then, para 16 has been quoted. Then, you have to come to that page 10. The aforesaid clause 16 does not specify the date from which the granted rate will become eligible, but only provide that director will communicate his decision on the claim to eligibility to granted rate. After the claim to eligibility to granted rate is decided by the director, the state government has to decide the date from which the granted rate will be paid after finding the resources for making such payment. If funds are available under the budget for making payment of the granted rate, the state government can issue the order specifying the date from which the payment of granted rate will be made. But if the budgetary allocation of granted rate have been adjusted, the state government will have to wait till such budgetary allocations are made. Thus, until the state government issues an order determining the date from which the granted rate will be paid to an educational institution, or to a member of the teaching and non-teaching staff of the educational institution, or to a member of the staff of the educational institution, after finding the resources for the same, granting it cannot be claimed as a matter of right, and no direction can be issued by court for payment. But once the state government issue an order determining the date on which the granting will be paid, a direction can be given by the court to make payment the granting rate, both current and linear. This conclusion is in accordance with the decision of the Supreme Court in case of State of Orissa versus Pratap Kumar Naik and others. In that case, each employee for granted rate has to be considered as per the granted rate order and section 7C of the Orissa Education Act 69. And it is for the state government to examine each and every case in accordance with the prescribed procedure for such granted rate. The conclusion is also consistent with the view taken by the privilege. Then we also try to come to paragraph 14. Page 12. In Chandigarh administration and others versus also, the Supreme Court has rejected the contention of Chandigarh administration that it was difficult to bear the financial burden towards the granted rate. The Supreme Court has held Coming to the contention of the appellant that Chandigarh administration will find it difficult to bear the additional financial burden if the claim of the respondent 1 to 12 is accepted, we need only to say that such a contention raised in different cases of similar nature has been rejected by this court. The state administration cannot shirk its responsibility of ensuring proper education in school and colleges on the plea of lack of resources. It is for the authority running of the administration to find out the ways and means of securing funds for the purpose. Orissa state, with a large section of people, including scheduled castes and scheduled tribes, who are so and so backwards, consistent with the directive principle of the state policy under Article 41, 45, and 46 of the Constitution, the legislature has imposed a mandate on the state government under subsection 1 of section 7C of the Orissa Education Act to set apart a sum of money annually for being given as granting aid to private educational institution in the state, subject to limits of economic capacity. The state government has also made the granting order under subsection 4 of section 7C of the Orissa Education Act, clearly indicating the relevant factor to be taken into consideration for deciding the eligibility of an educational institution or a member of teaching and non-teaching staff of such educational institution, keeping in mind the educational needs of the state. The state government cannot ignore such legislative mandate, adjust the direct principle of the state policy and the statutory provision of the Grant Order 94. Unless, therefore, there are no other pressing needs than education, the state government must set apart sufficient money for making payment of grant aid to educational institution or the teaching and non-teaching staff in accordance with the Grant Order 1994. For the aforesaid reason, the interim order is quashed and the director and secretary higher education and government are directed to reconsider the case of the petitioner for approval in the post of so and so. Thank you for answer. Now, but what will happen in the meantime, before I place your worship the judgment which is squarely applicable to my case, in some cases, the state has gone to Supreme Court, challenging the judgment passed by the single judge of this court, challenging the judgment of the tribunal. Those they have lost before the Supreme Court. I've given the copy of those the cases. What they have done, much after 2004 review order was passed, they lost before the Supreme Court and they extended the benefit to them under the 94 Grant Order, which are in fact the Supreme Court upheld the judgment of the tribunal and also by this honorable court. So if they have extended the benefit of the Grant Order under 94 Grant Order to, because the Supreme Court has dismissed those applications, now they have taken the plea. Because of that Anup Senapati or Loknath Vera's case, they say, because the court said that once a repeal is made, 2004, then there is no existence of 94 Grant Order from the beginning, from the date that is 1694. They cannot. So if that date says so, the persons, those who have got benefit after the 2004 Grant Order, in terms of 94 Grant Order,
there must be any confusion that they cannot retrospectively repeal all the effects of the 1994 order.
Sir, that is only our case, sir.
Right.
That's all I understood. Sir, kindly repeat judgment then. I only to supplement your lordship's view. Let me copy the judgment. I have given the other judgment. I'll not place it now, but your lordship may kindly see this judgment. This has been reported in 2013 Supreme Court, page 2113.
Yes.
So may I take your lordship to paragraph 27? This was for payment of pension. 27.
Just 1 minute.
Sir. Did you get it? That is,
yes.
Government of Andhra Pradesh versus Chaudhary Gandhi.
In
para 27.
In the case at hand. In the case in hand, para 27.
Yes. In the case at hand, the notification uses the phraseology of clause 6, clause 7 shall be substituted with the amending clause. The provision which is substituted by the amending rule does not obliterate the rights of the parties as if they had never existed. A substituted provision is the resultant factor of amendment rules, and it shall guide the consequence that follow from the amended rules. In Bhagatram Sarmas versus so-and-so, 1988 Supreme Court page 740, a two-judge judgment while dealing with the Punjab Public Service Commission, so-and-so making a distinction between two regulations, opining that absence of any provision giving regulation 83 a retrospective operation, the same cannot prima facie bears a great retroactive effect than intended. In this context, the court proceeded to state as follows. If I'll place the judgment which has been quoted, then actually kindly come to para 31. The 31 says that in Sagarwal's case, 2008 SCC, the issue was whether regulation that came into force on 25/10/95 could apply to a case where the cause of action arose prior to thereto. In the aforesaid context, expressing the panel statute which not have any retrospective effect or retroactive operation if commission of fraud was complete prior to that date, the question of invoking the penal provision contained in the regulation, including regulation 3 and 6, would not arise. Well, why I am referring to this paragraph 31? In my case, my application was pending before this Supreme Court from 1996, which was transferred to the tribunal under section 24B. So my cause of action arose was prior to 2004.
During existence.
Your also was project in another case to me that this is the judgment. Then you must be kindly come to page 37, para 37. In so-and-so case, Casey Aurora versus so-and-so, 84-3 SCC page 281, a notification was issued on 19th August 71, amending the definition clause of military service in Rule 2 of the rules. The notification was issued with retrospective effect on November 166 and restricted the benefit of military service up to January 10, 1968. A question arose whether a vested right which had accrued to the petitioner therein in 1969, 70 and 71 had been taken away. Dealing with the controversy, three-judge bench referred to the Constitution Bench, State of Gujarat versus so-and-so, quotation 83 SCC. In view of the latest pronouncement by the Constitutional Bench of this court, the law appears to be well settled, and the Haryana government cannot take away the accrued rights of the petitioner and the appellant by making amendment of the rules with retrospective effect. Then, paragraph 38. In Ramanand Keshav case, the court had observed that the amendment which has been made retrospective to legislate around the obstacles of Article 311 and Article 14 of the Constitution to bring about an artificial situation could not be allowed to stand. The Constitution Bench had posed the question whether law could be made destroy today's accrued constitutional right by artificially reverting to a situation which existed 17 years before and answered it in the negative. It may be noted here with profit that in the same case the Constitutional Bench has ruled, quotation, the legislature is undoubtedly competent to legislate with retrospective effect to take away or impair any vested right acquired under the existing law. But since the laws are made under the existing Constitution and to have a confirmed the does and don'ts the Constitution, don't speak of the Constitution, neither prospective nor retrospective laws can be made so as to contravene the fundamental rights. The law must satisfy the requirements of the Constitution today, taking into account the accrued and acquired right of the parties today. The law cannot say 20 years ago the parties had no right. Therefore, the requirement of the Constitution will be satisfied if the law is better by 20 years. We are concerned with today's right and not yesterday's. The legislature cannot legislate today with reference to a situation that obtained 20 years ago and review such march of events and the constitutional right accrued in the course of 20 years. From the aforesaid Constitutional Bench decision, it is graphically clear that the vested rights cannot be impaired by doing a law as that is likely to contravene the constitutional right. As stated there, the law is required to satisfy the requirement of the Constitution today, taking into account the accrued or acquired right of the parties today. The bench has emphasized that the legislature cannot legislate today with reference to a situation that obtained 20 years before and include the march of events and the constitutional right accrued in the course of 2 decades. Thus, vested and accrued right are not to be impaired. To understand that, To understand what is precisely meant by vested right, in the context of a service rule, it is necessary to understand and appreciate how this court has viewed the said right in the conspectus. The constitutional bench in so-and-so case, giving the validity of a notification that 51288 issued by the Indian administration under the proviso to Article 79 of the Constitution, whereby rule so-and-so of the Indian Railway Establishment Code, Volume 2 has been amended with retrospective effect. By virtue of the amendment, the quantum of percentage of the prolonging of allowances for the purpose of retirement and other benefit was reduced with effect from 173. The notification was challenged before Delhi High Court, which transferred it to the Central Tribunal after coming into force to the Central Administrative Tribunal Act 1985. The tribunal treated the said notification on executive instruction and replied that the said could not be accepted to be statutory amendment of the existing rule governing the running allowances. The said order was not challenged by the Railway Administration. However, notification was made on 5/12/88, the validity of which was challenged in some pending petition. As various benches of the tribunal rendered conflicting decision, the matter was referred to a larger bench and full bench of the tribunal replied that though under the proviso to Article 29 of the Constitution, the President has power to promulgate rules with retrospective effect, it is subject to the condition that rules do not offend any constitutional right or deprive an employee of his vested right. Like mentioned after retirement, as such deprivation of vested right is violated by Article 14 of the Constitution, being unreasonable and arbitrary. The three-judge bench of this court referred the matter to a larger bench by passing the following order. Two questions are raised in the present case, that is, what is the concept of vested or accrued right so far as the government servant is concerned? And two, whether the vested or accrued right can be taken away with retrospective effect by rule made under the proviso to Article 309 or by an act made under that article, and which of them to what extent. We find the constitutional decision in the Sonal case, 67 Supreme Court versus Skipover. Then we also kindly come to paragraph the constitutional bench analyzed the decision which have been mentioned in the referral order and observed as follows. Para 24. In many of these decisions, the expression vested right or accrued right have been used while striking down the improved provision which had been given retrospective operation so as to have an adverse effect in the matter of promotion, seniority, substantive appointment, etc. of the employees. The said expression have been used in the context of a right falling under the review, which was subtly altered with the effect on the anterior bill, and therefore the keeps the benefit available on in case at that time. It has been that such an amendment having retrospective operation which has the effect of taking out the benefit already available to the employees under the existing rule is arbitrary, discriminatory, and violating right guaranteed by Article 14 and 16 of the Constitution. We are unable to say that these decisions are not in consonance with the decision of personal law. Then para 40 is more important. After so stating, the Constitution bench stated that in the said case, the court was concerned with the persons payable to the employees after their retirement. It took note of the fact that respondents were no longer in service on the date of issuance of the improved notification, and the amendments in the rules were not restricted to their application in future. It was further observed that the amendment applied to the employees who are retired and are no longer in service on the date when the notification is issued. After referring to the pronouncement in so-and-so cases, para 33. Also, with this paragraph 33. Which has been quoted from 91 to ACC. After from being violative of right, then available under Article 31(1) and 19(1)(f), the improved amendment in so far as they have been given retrospective operation are also violative of right guaranteed under Article 14 and 16 of the Constitution, only now that they are unreasonable and arbitrary, since the said amendment in Rule so-and-so have the effect of reducing the amount of pension that will have become paid with the employees who had already retired from service on the date of issuance of improved notifications, as per the provisions contained in 25 code that was in force at the time of their retirement. We have referred to the aforesaid verdict in detail as deal with the vested accrued right in service jurisprudence, how the same cannot be affected by retrospective amendment. We have already applied the amendment to rule is not retrospective. Therefore, the factor on controversy whether respondent vested or accrued right to vegetate with a particular punishment so and so, as I will have to skip over. So ultimately, why I am pressing this judgment work. So far as my accrued right and vested right is in terms of 94, nothing else here. I don't say that whether my accrued right can be taken away by retrospectively by operation of this executive act 2004 grant order, which has been made pursuant to section 74(4). If your lordship will come to I have a semblance of right, that is the accrued right.
Always.
So, as the other judgment I have given, the judgment of this, only one order I will show you also, so that the part of the discrimination is confirmed with each other. The comparison which I have made, the order passed by Supreme Court and some other cases, so far the granted 94 is concerned. If you also look to page that is given along with a memo, the copy of the order passed by the Supreme Court as well as the order passed by the government. Last time I had given a copy to my learned friend also. That was in page mark also. Prospect kindly come to page 15. So, remember, that was given along with the copy. That is in the bonds. That is enclosed along with the main some document. Yes, I'll get it. I think my justice out my cost again. Also, kindly come to page 15. Oh, did I?
Where is your copy?
Sir.
All right.
You also look at page 15, 1 into 15, I page marked. Now this is
Running page
15
of the memo.
That memo, the compilation attached to the memo. Did you get it?
Yes. Yes.
You also see the order of the Supreme Court, 8/12/2017.
Yes.
Now I also come to page 16. We do not find a reason. It's a state appeal. All cases for states appeal. And all are relating to the entitlement of grantors of 94. We do not find a reason. Just like the case of the petition, Tribunal passed the order, the challenge before the Honorable Court that was upheld, then they had gone to Supreme Court. We do not find a reason to entertain this special petition, which are accordingly dismissed. The scheme has been, since the scheme has been framed, so skip over, the bank what they have done, they filed a review application. That is at page 17. And review application solely on the basis of this repeal provision. This is a repeal provision. And also the judgment in the Loknath Behrai's case, that is another part. The Loknath Behrai's case has not come at that time, but they have relied upon that because repeal provision is not there, the provision of 94 countries is no more there, they filed a review application. We are reviewing the petition, record of social petition, and are convinced that the order which review has been sought for doesn't suffer from any error apparent on the face of the record, dismissed. Then again they filed a review application, it will also be looked to the ground, the ground they have taken, that is at page 29. Para C. In any case, after the repayment of the grant of 94, the benefit of the grant cannot be extended. That is the entire case there. So this was also rejected. So this was rejected at page 32. Page 32. And this order was passed on 2nd May 2020. This order was passed even after that judgment was on the Talapatri case, which they rely upon. Sir, I'm reading. And upon it has come to a notice that there is a delay. Let's skip over. And the connected papers with meticulous care and do not find any justified reason to entertain this review application. Now you also see the government order. That is at page 33.
Mr. Rautra, there were some cases where the High Court had dismissed on the ground of delay. No, those FAOs were dismissed. These are not the cases. That means High Court had not gone into the merit.
In some cases,
Such case, or this is on merit?
in 2 or 3 cases, High Court has gone in merit, but these cases, I think that is on the ground of legal, on the ground of delay. And then implemented. It's the kind of which is 33.
That
So for the 33. Consequent upon the dismissal, I think that's guilty. Page 33. Consequent upon the dismissal of the review petition number, this is dated 24/11/2020. Consequent upon dismissal of the review petition number so-and-so, arising out of SLP number so-and-so, filed by the state of Orissa versus Shamlal Pradhan, and pursuant to the order of the Panel State Education Tribunal, dated 3/2013. Passed in July case number 235 of 2012, government has been pleased to accord their concurrence for approval of few number of posts in favor of India National Junior College Pipeline, Bargar for payment of grantee as per the grantee of 1994. As we see the right hand column, they have given the grantee rate with effect in terms of grantee of 94 with effect from 1695, 1/3, 2/3 like this. Now the entire plea they have taken, challenging my judgment of the tribunal, because of the appeal provision, we are not in a position to, we will not give any grantee rate. Because that no more grantee rate order is no more there, not in existence.
But that order is in under the direction of the judicial.
Yes, that is the order of the judicial, sir.
Yes.
Okay, come to the
So that's.
But there's some other point I want to were also interested.
So we'll continue tomorrow. Today there is no time.
Yes, yes.
You just heard Mr. B. Senior Counsel, Mr. Changram General Counsel for the petitioner in full for with the matter tomorrow for continuation of hearings when the counsel for the petitioners and other petitioners will place their submission. So, Mr.
The learned advocate general is not available tomorrow.
When he will be available?
When if the petitioners can complete tomorrow.
The lordship not just complete. They are there.
No, that is his proposition only. Let the petitioner complete it.
Sure.
Just recall the name of the council. What is the thing? Okay.
23rd and 24th.
Mr. Was present for the state and the party minister. Arnav Dehra and standing council. All right. You just repeat the submission tomorrow. Will not be available.
You'll have it.
So all the matters will come tomorrow.
Tomorrow 2 p.m. That's it, 2 p.m. 2 p.m.
2 p.m., 3 p.m. I do not know. It will come.
Let's say because it is in my Lord's mind, so that we want to see.
Tomorrow we post it. Oh, you're ready to sit up to 12 p.m. at night. I'm ready.
My Lord.
Open in jazz only.
No.
All right.
As convenient to us.
Next. What is the matter? Whether someone is there?
Become 63.
Your matter also will be taking tomorrow. There is no time. Tomorrow at 2. All right. 2 p.m. it will be taken up tomorrow. Because 2 p.m. already 2-3 matters are fixed.
So item 22. Again, please.
May I please?
Yes.
I have prepared a date chart.
This has not been issued in this matter. On last occasion, that is on 14/8, my lord directed me to take instruction in the matter. In fact, my lord, we can see that impugned order at annexure 15. There is an observation that the petitioner was found unsuitable for 2 times before the departmental committee in the interview held on 21/11/2008 and 24/2/2009. That is why my lords have directed me to obtain instruction and to produce these 2 proceedings for my lord's perusal. I have obtained those 2 proceedings.
This is pending since 2013. Notice has not been issued.
They are dismissed for default.
Yes, yes,
Separate hearing
yes.
list.
2014 dismissed for default and restored in 2000.
This is the second round of litigation. First it was filed, then order was passed. They did not file any counter. Accordingly, order was passed. That order I have annexed along with this writ of application. And now from the date chart, it will be clear to your lordships. It is admitted fact that the petitioner was the only candidate out of 4 posts, only one applicant, the petitioner, and he was eligible as per the that he has completed 10 years and applied, and all the recommendations were made by the competent authority, and that was sent to them. Then the government set over the matter. Then he was called for the
these 2 proceedings. Yes. That was considered by a 4-member committee. Well, out of 4 persons, 3
my specific that I asked you to take instruction, what is his deficiency? Why he was not considered?
Yes. Committee considered his case, but not found suitable for recommendation to the government to be appointed as a notary.
Not suitable, there should be some reason.
Yes.
So there are so many candidates.
Now we understand.
Yes.
One line, because of this candidate is not so suitable, will not take.
So that is, they have.
There is one proceeding of 21/11/2008. There he was considered.
Yes. You can
They
see
recommend others.
page serial, you can see page 4. And that is his serial number 15. I have highlighted. The name of the petitioner, serial 15. He also appeared before the committee.
Do you think this is a very transparent procedure? No sheets, nothing of that set. How they have enumerated only the 4 names, 5 names they are pushing forward.
Yes. Yes.
No, considering these are the candidates.
We do not have the trust in all and everyone in this world. That is why you say that when the selection process is going, you follow the certain procedure which is transparent, not to be published in the public. But when the records will be called by the courts, that can be seen that there is a transparent procedure, proper assessment was made. Simply some names are there. No, why? On the basis of why the other persons who are given.
Well, in the first page, you also can see.
Yes.
Towards
Marks has been
fifth line from the bottom.
Yes.
After considering their length of practice, verification of documents, their willingness, interestedness to become notary, their basic knowledge as to duties of notary, and considering other factors, the committee hereby recommends the following persons at first for their appointment as notary against each of the places of practice. So, out of these persons were only recommended, not the case of the person has been rejected. That is not mentioned here.
Also not recommended.
No.
So what does this non-recommendation means?
No. At the first instance, these persons were recommended.
Yes.
The wording is, the committee hereby recommends the following persons at first.
for their appointment. So on.
Yes.
So this procedure is followed every year.
Yes. And out of this, you will see on the second page, out of 4-member committee, now.
You have retired.
Yes.
Have come here and retired.
May I know the date, madam, that committee recommendation?
21/11/2008.
The second one, that is the last one is
24/2/2009.
2009.
Yes.
Yes. Your lordship directed them to file an affidavit.
No.
Then I shall advance my argument on that.
No, they have not filed. We asked them to take instruction.
Yes, madam. Let me,
All right.
page 25, your lordship may see.
Right.
Page 25 of my writ application. How I applied from my date chart, your lordship may see that I applied on 5/5/2005, serial number 2. Then
Mr. Muduli,
yes,
since 1981, the apex court time and again saying when this is an oral interview only,
yes,
you must maintain the record on what had someone got what. At least you maintain that part, the knowledge of law. You are saying the knowledge of law, how the knowledge of law was adjudged by the committee. We don't know anything.
There should be separate marking.
That should be. That is the standard procedure.
So that when they challenge, that can be considered that at least some process where there some marks were given.
Because we want to arrest the colorable exercise, arbitrariness in the selection procedure.
They are judicial officers.
No. Don't forget about the judicial officers. Judicial officers are never granted any exemption by the Supreme Court decision. And recently you have seen that the total the departmental proceeding of a High Court was completely quashed by the Supreme Court regarding promotion of the superior judicial service. So that is not a plea. The principle of the transparency in selection applies for all.
Hello, let me discuss.
Judges are not the demigods. Don't treat them like that also.
Let me discuss with my officers as to whether there is any such tabulation register for giving marks in
a short affidavit with these materials. And only midway is that if you come that we will consider his case, I will not go into the detail because court have other valuable time to invest on those matters. Because there is no semblance of how he was assessed or how the other people were. Maybe they are very good people for that post.
There should be some basis.
For that reason,
there should be some basis.
Lighting.
How many persons? These are the persons. Make a table and show this is the person. So marks you are getting it. We are recommending at the first phase, the first 1 to 5.
Yes.
And then say the second phase and rest of the panel I am just considering.
Let me discuss with my officer, then I will come back with an affidavit.
Okay, we will come with an affidavit.
Yes.
All right.
But that will be better because my lawyer senior will also get an opportunity.
All right, we are listing the matter on 5th September. With the request of Mr.
Last chance.
This is only the second chance.
P.K. Muduli, Additional Government Advocate.
No, I have complied the file.
The matter was listed on 5th September 2023. Meanwhile, the opposite parties shall file an affidavit showing the methods of selection and assessment of and how the assessment was made of the candidates. Stop. Today, in terms of our order dated 14/10/2023, Mr. P.K. Muduli, Mr. Muduli, an additional government advocate, has produced before us the recommendation made by the meeting of the Notary Committee held on 21/11/2008 for the district of Moyvanj. And the minutes of the meeting of the notary committee held on 24/2/2009. Stop. Copies are taken on record. Those written instruction are taken. Written instruction with the copies of the minutes are taken on record. So, MS S. Das, Dr. S. Das, Parent Counsel, appears for the petitioner. Let us see what happens. This is the copies taken.
ସେଇ ଯୋଉ ଜଜମେଣ୍ଟ ଗୁଡା ତା ଦେହରେ ଅଛି ମେନ୍ ତା ଦେହରେ ମାର୍କିଂ ଅଛି ସେ ମେନ୍ ସାଇଜ କିଛି ପଡେ ନାହିଁ ଆପଣ ବାନ୍ଧି ନାହାନ୍ତି ନା ନା ଆପଣ ବାନ୍ଧିକି ରଖୁନାହାନ୍ତି ପିଲାମାନେ ସେଟା କେମିତି କରିବେ ସବୁ ଜାଣ କଣ ସେକେଣ୍ଡ କପି ମାନେ ବାନ୍ଧି ଗୋଟେ ହେଇଗଲା ଆପଣ କାମ ଗୁଡା ମୋ ପାଖରେ
Right, you know.
My lord.
Oh, together. We're fixing on 29th of August.
Your lords may fix 29th. Your lords may call it. I'm filing the written note already. Your lords may call it 2 p.m. Hardly I'll take 15 minutes only.
No, this lawyer's 15 minutes, I know.
I'm sorry.
He was taking only 5 minutes and today he's...
But I'm filing the written note, your lordship. So in the sequence of events.
What day you file it, please?
My lord, on that. Yes, your lordship. Your lordship may call it on 29th at 2 p.m. My lord.
You will not be listed on 29th and 2023 at 2 p.m.
I am for the opposite party also.
You are also appearing for the
opposite party.
On behalf of Mr. Dayananda Mahapatra, Pranab Singh Deo, my lord.
You are not on record?
Yes, my lord. I am on record, my lord.
Right. What is item number?
80, the last 80.
It was
single.
another
Light is single. PK single. Respondent. And Mr. A. Mishra. You are also there?
My lord, I am there.
Mr. PK Tripathi and Mr. A. Mishra and counsel case for the applicant. October and other thing, only those matters we have heard within the month of September. Please send up to the completion of the judgment, go take out phase marks.